Good morning and welcome to the fifth meeting of the Education, Children and Young People Committee in 2026. Today we are doing day one of Stage 2 proceedings for the Children, Care Experience and Services Planning Scotland Bill. We will be joined, hopefully soon, by the Minister, Natalie Dawn Innes, Minister for Children, Young People and the Promise, and I welcome her supporting officials who are with us at the moment. The officials seated at the table are here to support the Minister, but are not able to speak in debates on the amendments. Members should therefore direct their comments or questions to the Minister. During the meeting, we'll be welcoming a number of non-committee MSPs who are attending for part or all of the session to speak to their amendments and to participate in debates. Before we begin today, as this is our first day of Stage 2 for this bill, I will briefly explain the procedure we will be following this morning. The amendments that have been lodged on the bill have been grouped together. There will be one debate on each group of amendments. I will call the member who lodged the first amendment in that group to speak to and move that amendment and to speak to all other amendments in the group. I will then call any other members who have lodged amendments in that group. Members who have not lodged amendments in the group but who wish to speak should catch my attention. If she has not already spoken on the group, I will then invite the Minister to contribute to the debate. The debate on the group will be concluded by me inviting the member who moved the first amendment in the group to wind up, and following the debate on each group, I will check whether the member who moved the first amendment in the group wishes to press it to a vote or to withdraw it. If they wish to press ahead, I will put the question on that amendment. If a member wishes to withdraw their amendment after it's been moved, they must seek agreement of other members to do so. If any member objects, the committee immediately moves to a vote on the amendment. If any member does not wish to move their amendment when called, they should say not moved, but please note that any member present may move such an amendment. If no one moves the amendment, I will immediately call the next amendment on the marshalled list. Only committee members are allowed to vote. Voting in any division is by a show of hands, and it's important that members keep their hands clearly raised until the clerks have recorded the vote. The committee is required to indicate formally that it has considered and agreed each section of the bill, so I will put the question on each section at the appropriate point. Now we have covered the procedures we will be following today, I would move to the substantive business today in consideration of amendments, but because the Minister is still not here, and I do accept her office have informed me that she's stuck in traffic, but we will have to suspend the meeting until the Minister gets here, so I suspend this meeting. Okay, thank you very much and welcome back. We will move on to our Stage 2 consideration, and I call Amendment 87 in the name of Sue Webber, group with Amendment 225. Sue Webber to move Amendment 87 and speak to both amendments in the group. Ms Webber.
Good morning, Convener. It's nice to be back on a Wednesday morning in Committee Room 1. I would like to speak to my Amendment 87, which is in this Group 1, and it's really there to seek to place prevention, minimum intervention and family reunification at the heart of the bill, and to require robust consideration of the alternatives before young people are removed, to ensure access to services that keep families together, and to strengthen the evidential standards in child protection orders. Because this bill, as we will be reminded later on, I'm sure, and many times, is part of the promise, which aims to keep families together wherever safe. And I've been working, albeit later on, or close to this, with the Parents Advocacy and Rights Group, who came to meet me with some compelling evidence that I was taken with. So that is why I've placed the amendments I have for this bill. And they are there primarily, I suppose, because the independent review of children's care led to a commitment to implement the promise, recognising the outcomes for children who are looked after have been unacceptably poor, and that the core principle of the promise is that children should not be removed from their families unless it is absolutely necessary. And despite this commitment, the number of children entering care has continued to rise, many of them at or shortly after birth. Child protection orders are the key mechanisms through which children are removed from their parents, and usually their mothers. And these decisions are often taken in urgent circumstances, yet they have immediate and life-changing consequences for so many, for the children and the families. And as currently drafted, the bill represents us, it's a missed opportunity to refocus children's services on prevention. Yes, I will, Mr Mason.
John Mason.
I thank the member for giving way. I mean, I've got some sympathy for the idea of having general principles in a bill, but she just mentioned prevention, and in was it E, it says preventative measures, which seems to me quite a vague term. Does she not think it's a bit vague to just put that in?
Sue Webber.
There's a whole host of things that could be coming under that banner of preventative measures, but far too often those preventative measures are not fully funded, and we'll come to amendments later on in the bill that are about this, that it's often more easy or more convenient to take the child and put them in care than it is to provide the wraparound support that a family may need that comes into their home to help. So I've been perhaps broad in the language, but the intention is the same. There are many things that could be used to prevent a child from being taken into care, should the local authorities see fit to do so.
The member take an intervention?
Yes.
Martin Whitfield.
Grateful convener. And isn't it right, because we are talking about young people and we have to go back to the basis of getting it right for every child, that the individual support and assessment one individual child may meet is very different from those that others, and that the phraseology that's been used in the amendment that you're proposing allows a very wide scope of input and support to prevent what the clause is seeking to do, the removal of the child from the family.
Sue Webber.
Thank you, Mr Whitfield. I suppose you're right there, because we do hear it time and time again. It's about getting it right for every child, and every child is very different. Every family circumstance is unique, and if we have a one-size-fits-all solution, you're failing everyone. We want to make prevention a priority, or I want to make prevention a priority, as does the Parents Advocacy and Right Group that came to see me. We want to reduce family breakdown, stem unnecessary entry to care for children, or when care is necessary, to make sure that it does not do more harm than good. My amendment inserts a principle clause at the front of the bill. It sets out in plain terms, plain language, what Parliament expects of the children's care system. It firmly places prevention and early support services at the heart of the bill, and to help ensure that children do not enter care simply because no alternative support is available. We must have the child's welfare at the heart of this. Everything taking the child away must be evidence-based and proportionate. These interventions must be proportionate, because we want to promote the upbringing by families with the presumption that welfare is best protected by remaining with parents and siblings, even when residential arrangements are in place. Prevention first for children at risk of becoming looked after, and reunification support at every stage for children who are looked after. It is a duty on public bodies to give effect to these principles, and I want to record these steps taken in the Child's Plan, because after all, the purpose of my amendment and this bill is to align the bill with the promise's emphasis on early help and whole family support. And with the evidence that this committee took at stage 1, stakeholders want that clarity of purpose and that shared framework guiding practice and resourcing. Thank you, Convener.
Thank you. And can you move your amendment?
move my amendment.
Thank you very much. I call Paul O'Kane to speak to Amendment 225 and the other amendment in the group. Mr O'Kane.
Thank you very much, Convener, and I draw members' attention to my register of interest that my husband is a service manager in children and families and a registered social worker. I don't intend to speak for too long on this amendment, as it is a fairly straightforward and self-explanatory amendment, but I think everyone in the room and everyone more widely is familiar with the words of the Oversight Board's third report, which was published a year ago tomorrow, which says that 2025 marks the midway point since the promise was made to when it must be kept. But Scotland is not halfway towards keeping its promise. There have been unexpected events, delays and unnecessary barriers. This means that there are children and young people who are not receiving the care and support they need. And that means for some in the care community, the promise has already been broken. That report was a wake-up call for everyone, and I hope in particular for the government. And the government has long hung its hat on the promise that there would be a bill in this session of Parliament to advance the goal that we all share, and to make up for lost time and missed opportunities, many of which I believe the board were referring to in the quote that I just read. I think what's perhaps more pertinent as well in terms of this amendment, in terms of what the Oversight Board said in their report, they recognised much of that, saying that the upcoming Promise Bill to be lodged in Parliament represents an opportunity and a risk. The upcoming Promise Bill. That is how they referred to the legislation that is before us. So I do think that we should talk about what we are talking about. And that is why this amendment would rename the short title of the bill to do just that, to make the title the Promise Scotland Bill. I'll take Mr Greer, yes.
Ross Greer.
Grateful for that. I have a lot of sympathy with what is outlined here. My concern, and I'd be interested in his thoughts on, is the feedback that we've had from so many people in the care experience community. I think that we all recognise that this bill will not fulfil the promise, but by renaming it the Promise Bill almost suggests that we think it will. Is there not a risk of further eroding the trust that many care experience people have in the process by making it look like we're patting ourselves on the back and we think job done, when we know actually there's at least one more bill that's going to be required to do this?
Paul O'Kane.
So I thank Mr Greer for his intervention, and I recognise what he's saying, and I recognise some of the criticism around, or the concern, I suppose, around renaming this. What I would say is I've heard the flip side of that as well, where I've met with many care experience people through the cross-party group on care leavers, for example, where they have referred in shorthand to it as the Promise Bill. I think what we need to do is perhaps strike a balance, and to my view we could perhaps refer to Promise 1 Bill and Promise 2 Bill, and I don't want to get into sort of the weeds of all of that, but I think actually in terms of focusing minds and focusing attention, I think we should call the bill what it is, which is an opportunity, and I think there still is mileage in this being an opportunity to try and begin to fix some of the challenges to which Mr Greer refers. But I fully accept, and I made these comments as he knows at stage one, that this isn't going to do everything we need it to do, and it needs to go further and faster. So I would maintain that I think renaming it would be helpful, but with the caveats that he points out, which I think are very fair. Because I think, in summing up, Convener, the challenge to the government and to everyone here today is that if we are serious about keeping the promise, and that we want this legislation to be part of that, although not the full solution, then I think we should call a spade, and if we're unwilling to do that and call it the Promise Bill, because we're going to just acknowledge that as drafted it's going to be another missed opportunity, and we're going to accept that at this point, then it really is going to, I think, set us back, and we are not going to be able to meet the aspiration that I think we all share. So I'm very grateful, Convener.
Thank you. Minister.
Thank you, Convener. I'll thank Sue Webber in the first instance for explaining the rationale behind Amendment 87. I agree that the welfare of a child or young person should be paramount to any decisions taken to improve their safety and well-being. Many of the principles that Ms Webber has set out in Amendment 87 are already provided for in Scotland's extensive legislative and policy landscape, including placing the best interests of the child at the heart of delivery of the care system under the Getting It Right for Every Child approach. Now, the Children Scotland Act 1995 and the Looked After Children Scotland Regulations 2009 already place duties on public bodies to ensure that decisions made about the care and protection of children and young people are made with their best interests at the centre. In addition, the GIRFEC approach, which underpins Scotland's child protection guidance, places the child's voice and their best interests at the heart of decisions that affect them and the support they are provided to improve their safety and well-being. The process of any assessment of well-being within GIRFEC should start with what the child or young person needs at its heart, before considering what measures their family should then have in place to support those needs. In some circumstances, the needs of the child will differ from those of the rest of their family, and the emphasis should ultimately rest on the child's needs at the heart of any decision-making or plan. This amendment also places a duty on public bodies to record their adherence to the general principles outlined in the child's plan for an individual child or young person. And this conflates the purpose of the child's plan with an assessment of options when planning support for a child or young person. The child's plan is non-statutory unless the child or young person is looked after under the Looked After Children Scotland. Yes.
Sue Webber.
Thank you, Convener. And surely in terms of transparency and accountability, all of this, the preventative measures that are considered, should be documented somewhere so that there is that record. We are in a world where people sometimes feel things are being done to them, and no matter how old these young people are, surely having a record of what has been considered, the measures that may or may not have been taken, this is only due diligence and is only right for that child.
That may
Minister.
be. And that's something that I would be happy to debate with Ms Webber, but I don't feel that the child's plan is the right place for that. Under current legislation and practice, all information which is relevant to the action taken to improve a child or young person's well-being, of course, should be included in their plan. Including an assessment of alternative options in a child's plan, as set out in this amendment, would risk complicating a child's plan for the child or young person and their family. Now, I am committed, of course, to keeping the promise, including keeping families together where it is safe and within the child's best interest to do so. And I do understand the intent behind this amendment, so I would be happy to consider what might be possible to reflect these principles through a targeted or a more refined approach at stage 3. So I would ask Sue Webber not to press this amendment, and if she does, I would encourage members to vote against it. Paul O'Kane's Amendment 225 does have some attraction, and not least because we have all used and still use the Promise Bill as shorthand for discussing it, myself included, and a big reason for that is because I was talking about this bill long before the formal title was named and was considered. But I'm afraid this amendment would require us to deviate from existing practice and convention, whereby the title of any bill should reflect the actual substantive content of the bill, which includes measures that will help to keep the promise. I think Mr Greer raised a really important point in terms of the feedback that's been received. And of course, there is wider work entailed in relation to delivery of the promise that goes far beyond even another bill that includes non-legislative measures. So I feel the title, naming it the Promise Bill, it could be misleading, it could cause confusion. Yes.
Paul O'Kane.
It would be useful, I think, because in her opening she referred to the fact that at this committee and in the chamber she's referred to it as the Promise Bill. Why did she do that? I appreciate what she's saying about naming conventions of bills, but does she believe that this is a crucial opportunity, as was outlined by the Oversight Board, to keep the promise? And if so, why would she not be willing to name it as such?
Yes, I've just laid out, Mr O'Kane, that I don't believe this bill is the be-all and end-all to deliver on the promise. I do believe that, as I've stated in committee before, there is a huge amount of wider work underway in a non-legislative fashion that is in line with delivery of the promise. It is not all focused on the provisions in this bill. There has been already 6 years' worth of work ongoing to deliver on the promise.
I wonder if she would take an intervention again.
Yes, I'll take.
I'm very grateful. I don't think anyone is suggesting that this is the be-all and end-all. In fact, I would say we're quite far away from that. But it is a statement of intent. Does she recognise a lot of what was outlined in terms of, naming this as that aspiration?
Minister.
I do understand the intent behind this. I think I said that quite clearly. However, in terms of actually what this bill is aiming to deliver, the feedback that I've heard from young people, I don't believe that this is where our attention should be lying. I understand, as I say, that I have called it the Promise Bill in shorthand because, as I say, I've been talking about this bill for much longer than when it was introduced in June. But as I've said, I believe that the current title of the bill does represent what the bill does. And I've been clear that I think anything over and above that might lead to confusion or may be misleading. So I would, while I, as I say, understand the intent behind it, I would ask Mr O'Kane not to move this amendment, and if he does, I would ask members to vote against.
Thank you. I call Sue Webber to wind up and press or withdraw Amendment 87. Ms Webber.
Thank you. I will keep my remarks brief because I know we've got lots to do, but I'm curious as to know where the Minister thinks this information should be held for it, and that given that so much of it is already catered for within our legislative landscape in Scotland, perhaps it shouldn't be a challenge, therefore, for the members of the committee to support my amendment today. I am going to press ahead, but should it fail, I will seek to work with the Minister to find a way for the broader principles that I have laid out to become as successful, perhaps, at Stage 3 convener.
Thank you. The question is that Amendment 87 be agreed to. Are we all agreed? No. We're not agreed. There will be a division. Those in favour of Amendment 87? And those against? Thank you. The result of the vote on Amendment 87 is yes 3, no 7. Amendment 87 is therefore not agreed to. I call Amendment 1 in the name of the Minister, grouped with Amendments 2, 3, 4 and 126. Minister to move Amendment 1 and speak to all amendments in the group. Minister.
Moved. Sorry, Convener.
So I'm asking you to move Amendment 1 and then speak to Amendment 1 and all amendments in the group.
Sorry, I'm a little bit behind. That's fine. I'm organised here. OK, thank you, Convener. I will just I move Amendment 1 in my name, and I welcome the opportunity to speak to this group of amendments which relate to kinship care assistance. Amendments 1, 2 and 3 form a coherent package of government amendments designed to strengthen the statutory framework for kinship care. Together, they introduce a clear right to a comprehensive needs-based assessment, ensure local authorities have regard to statutory guidance and improve national oversight through proportionate information sharing powers. For kinship carers and the children that they care for, these amendments are about making support clearer and more reliable, so that families know what help they can ask for, how it will be considered, and they can expect greater consistency across Scotland. At their heart, they are about ensuring that children growing up in kinship care are properly supported in line with our commitments under the Promise. They introduce a clear right for eligible kinship carers to be offered and to request a comprehensive needs-based assessment so that support is considered in the round and reflects families' individual circumstances. This assessment is intended to be child-centred and to align with existing GIRFEC practice and the Child's Plan, supporting rather than duplicating current assessment and planning processes. Alongside this, my amendments strengthen the role of statutory guidance and introduce proportionate information sharing powers, helping to improve consistency, transparency and national oversight so that we can better understand how kinship support is working across Scotland while respecting local delivery. Now, I understand the intent behind Jeremy Balfour's Amendment 4. Indeed, kinship carers should be properly supported and treated fairly, and my amendments seek to achieve that. However, I am not able to support Amendment 4. The parity in assistance envisioned by this amendment is unclear. While kinship care assistance is a defined concept in legislation, there is no equivalent concept in respect of foster care. So, as drafted, this amendment would introduce a broad and undefined parity requirement that risks blurring the long-established distinction between kinship care as family-based care and foster care as a commissioned service delivered on behalf of the state through formal arrangements, and could give rise to unintended legal, practical and financial consequences. In particular, Amendment 4 does not distinguish between assistance intended to meet the costs of caring for a child and payments associated with foster care as a commissioned care service. Now, Minister Ministers already have the power to specify and require payment of allowance rates for both foster and kinship carers, and we are strengthening that further through Amendments 20 and 21 in a later group in relation to uprating and transparency. I consider this to be a more targeted and proportionate route to fairness. I hope Jeremy Balfour will agree and will not press Amendment 4. If he does, I would encourage members to vote against it. Miles Briggs' Amendment 126 appears to align closely with the commitments set out in the draft Kinship Care Vision Statement. That vision emphasises the need for greater transparency, for clearer local offers and improved access to information so that kinship carers are better able to understand and access the support that's available to them in their local areas and nationally. One of the purposes of the bill is to ensure that children and families with care experience feel supported, informed and empowered, and Mr Briggs' proposal contributes meaningfully to that aim. I would just seek to clarify what Mr Briggs intends in relation to local and national levels, and I'd be happy to work with the member to bring back a suitable alternative amendment remedying this at stage 3. But I encourage members to support my amendments 1, 2 and 3.
Thank you. I call Jeremy Balfour to speak to Amendment 4 and other amendments in the group. Mr Balfour.
Thank you, Convener. Good morning to the committee and to the Minister and to our team. Amendment 4 seeks to ensure kinship carers are on an equal footing to other providing care such as foster carers. Both are taken in children at the point of need and should not be differentiated whether it is a relative or state-supplied foster carer. This particularly applies to financial support and also social work support. The Social Justice and Social Security and Social Justice, I've only sat in it for 9 years, committee took evidence on this a number of years ago. And actually within this very room we had a number of kinship carers came and gave evidence. And what was clear is that they feel that they are the Cinderella service around this. And I welcome the Minister's amendments, but I do think we can go further still in regard to recognising the vital role that they play in our system. Children First state that kinship care now accounts for 35% of all children who are looked after in the community. But if you look at regard to the financial contribution and also the other support from agencies, they do not give the same. Many kinship carers will stop or reduce working to take on these additional caring responsibilities. 80% of kinship carers report financial hardship. Even in this Parliament term, kinship carers will be paid different amounts depending on what local authority they lived in. Now, I appreciate that the Scottish Government have dealt with that issue at this moment, and I appreciate also that some of the amendments that will come later are seeking to address that. But I am still concerned that in future governments we could end up with kinship carers not getting the amount of money they require to meet the financial need that they are given. My other concern, and again this comes from kinship carers directly, is that they find it very difficult to access the services that they require, whether that is social work, education or health. And there is a distinction made within most local authorities between foster carers and kinship care. Now, I do fully accept the Minister's point about definition is an issue here, and I do accept that this amendment is very broadly written, and that was deliberate so that we could start a conversation. I would be interested when the Minister concludes whether we could look maybe not just at the financial need, but how do we get the right support in regard to social work, education and health. And absolutely.
John Mason.
I thank the member for giving way. I accept that this is not just about finance, but it is partly about finance. Does he have any idea what this would cost?
Jeremy Balfour.
Well, at the moment, the cost is being met by each local authority because the Scottish Government are funding it. So there is no cost. This is also not a one that you can budget for because we do not know how many people will go into kinship care on an annual basis. It's a bit like the social security payments that we make. It is an open budget. Now, we can give estimates. There should be no greater cost in regard to this than is happening at the moment, because kingship carers should be getting the monies that they are due. It's whether they are aware of that and whether they are accessing those services. And I think also, to be honest, to put a financial cost on this is coming from the wrong end. These families are taking in very vulnerable children at a very difficult time in their life. And whatever cost they are given, it is going to be far less cost than if they were going to have to go into care or into fostering. And I think the overwhelming majority of people that do kingship care do not do it for financial gain. They do it to protect some of the most vulnerable people in our society. So to conclude, Convener, I do hope that we can look at something, maybe at stage 3, around that social work, health and education, and making sure that those who take in vulnerable children are given the support that we need. Thank you.
Thank you. I call Miles Briggs to speak to Amendment 126 and other amendments in the group. Mr Briggs.
Thank you, Convener. Good morning to members, Minister and your officials as well. And I'm pleased to start, as Jeremy Balfour has, that we are putting, I hope, kinship care at the heart of the bill, and I recognise what the Minister has said in terms of wanting to improve that, because I also sat on the Social Justice and Social Security Committee alongside Jeremy Balfour, and I think the Minister, actually, when we took evidence from families, and it was some of the most compelling evidence, and something I know as a committee we promised we would make sure we would take with us through Parliament. So I'm pleased that we've had this opportunity to start that process as part of the bill. The intention behind my Amendment 126 is to require the Scottish Government to take steps to make sure that kinship carers can more easily and accessibly find and access support. As the promise says, the Care Review has heard from many kinship families about the lack of support that they have in caring for children and the fear that sometimes they have for asking help. It also says that support must recognise the particular challenges that can exist for kinship carers. There must be recognition that kinship carers may be caring for deeply traumatised children and that they may experience their own pain at the consequences of what may have been family breakdown. Scotland's care system depends heavily, as has been said, on kinship carers. It already is the most common care arrangement in the country, with 35% of children looked after in our community. So I think it's important we do look towards how the bill will strengthen arrangements and that information sharing. The Minister highlighted local. I included that because I think it's important to look at the national spread around support for kinship care. Here in my own region in Lothian, I think that's more easily accessible than when you look towards the Highlands and Islands, for example, and how that is provided both at a very local level, but also nationally coordinated as well. So I wanted to make sure that we captured both as part of this amendment. It's quite clear from evidence committees over many years in this Parliament have taken that the offering to kinship carers is not what it should be. The informal arrangements around kinship care often present that, but I don't think that should prevent this bill and all of us trying to improve that offering and where support should step in, not in a crisis situation, but in a preventative situation. So I'm happy to work with the Minister on tidying up this amendment, on further discussions for stage 3 as well. I hope at the end of this process that offering for kinship carers will be a really improved part of the promise and part of this bill. We need to turn some of this on its head. We need to look towards where our public services intervene earlier. And for the promise to be a success, we need to radically change, I believe, the way kinship carers are supported and seen by public services as well. So I hope this amendment seeks to take that forward in that way, and happy, as I say, to work with the Minister to try to improve this. Thank you.
Thank you. And I call on the Minister to wind up the debate. Minister.
Thank you, Convener. And I thank members for their comments. I'll keep this brief, just to kind of further on the support for kinship carers. Members will be aware I'm obviously very pleased to bring these amendments forward at stage 2. I have been out to many visits, and of course it goes back to my time on the Social Justice Committee in relation to taking evidence from kinship carers, and I knew that something needed to change to support kinship carers further. They play an absolutely vital role in keeping children with their families. It is a preventative measure, as either Mr Briggs or Mr Balfour highlighted. This is leading to a reduction in children going into care, and we absolutely need to make sure that these families are appropriately supported. In December, we published our draft vision for kinship care, which sets out a clear national direction for how kinship care should be supported in Scotland. It sets out a shift towards earlier, clearer and more consistent support, rather than families having to reach crisis points, as Mr Briggs highlighted. Now, this vision is a working draft at the moment, and we're continuing to test and refine it through engagement ahead of the final publication of spring. But that, of course, goes hand in hand with the amendments and the legislative changes as well. So I believe that taking both that we are presenting a really strong package for kinship carers that will mark a step change in support. And I'm pleased to, as I say, work with Mr Briggs ahead of that stage 3 as well. Thank you.
Thank you. The question is that Amendment 1 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 2 in the name of the Minister, already debated with Amendment 1. Minister, to move formally.
Moved.
The question is that Amendment 2 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 3 in the name of the Minister, already debated with Amendment 1. Minister, to move formally.
Moved.
The question is that Amendment 3 be agreed to. Are we all agreed? Yes. That is agreed. I call Amendment 4 in the name of the Minister. Sorry, I call Amendment 4 in the name of Jeremy Balfour, already debated with Amendment 1. Jeremy Balfour, to move or not move?
Not move.
I call Amendment 126 in the name of Miles Briggs, already debated with Amendment 1. Miles Briggs, to move or not move?
Not moved.
I call Amendment 88 in the name of Ros McCall, grouped with Amendments 127, 89, 128, 5, 90, 6, 91, 7 and 86. I point out if Amendment 128 is agreed to, I cannot call Amendments 5 and 90. If Amendment 5 is agreed to, I cannot call Amendment 90. This is due to preemptions. I call Ros McCall to move Amendment 88 and speak to all amendments in the group. Ms McCall.
Thank you, Convener, and thank you, Committee, for hearing my amendments. If I start, I'm going to speak to my amendments first rather than the rest in the group. I'm going to take them individually just to give an idea of where this is coming from. Amendment 88 goes to the heart of whether aftercare is a right or a favour. At present, the bill allows the local authority to decide that a young person's, and I quote, welfare does not require aftercare. Now, in practice, that wording gives too much room for subjective judgment and, frankly, for financial pressures to influence the decision. So my amendment removes that discretion. It makes it clear that aftercare should not be a starting point, not something that a young person has to justify or to fight for. In the real world, care-experienced young people already face instability in housing, education, mental health. They should not face uncertainty about whether the support that's promised to them in law will actually be there when they need it. So if we leave this discretion in place, we risk enshrining inconsistency in statute. So the support depends not on need, but on geographical budgets. So I think that underlines the fairness and the intent of the bill. Amendment 89. Turning 26 doesn't magically resolve the trauma that, or instability that a young person has gone through. So this amendment is hoping to fix an age limit and put in a needs-based approach. It recognises that care-experienced people tell us repeatedly that their journey doesn't follow neat timelines, that they need support when they need the support. Some young people may be ready to step away from support earlier and others may need it longer. So this amendment simply allows the system to respond to reality. I will. Thank you.
Very grateful. And I have a lot of sympathy with what's intended here. What strikes me, though, is almost that 88 and 89 are trying to do the opposite, because I think the member quite rightly in regards to 88 pointed out that where too much discretion is given to local authorities, things like financial pressures come into play. My concern around 89 and giving the local authority the discretion to judge whether or not it's necessary is going to result in local authorities actually cutting off support earlier than would have otherwise been required. Is that a concern that the member has at all? If we empower local authorities more to make this judgment themselves, have the system rather than the young person make the judgment?
Yeah, and I thank Mr Greer for the intervention. I actually think it's the other way around. I think when we have such restricted processes that it ends up being a tick box exercise, the lines are so precise that if it falls one side of the line it is given, if it falls the other side it is not. I think if we have a variance and an ability for local authorities to look at that, then they're able to provide the support that's required, and that's what these amendments are trying to achieve. Amendment 90. If we accept that needs, not birthdays, should drive aftercare decisions, then the principle must apply consistently throughout the bill. So Amendment 90 ensures that we do not undermine one part of the legislation by leaving a contradictory age threshold elsewhere. And finally, Amendment 90. By strengthening the needs-based approach across the section, it gives practitioners clarity and young people confidence. It protects the bill from future challenges and ensures internal consistency. So if I can turn to other amendments, with Amendment 6 in the name of the Minister, I would just like to ask the Minister if it's possible in our information. We're looking at an ability for the Parliament to change the age range, and I was wondering if the Minister would be willing to move that to an affirmative procedure rather than a negative procedure, just so that any scrutiny of any age range changes could come back to Parliament. And I just wanted to highlight that, Convener, and thank you very much indeed.
Thank you. And can you move Amendment 88?
Yes, I move Amendment 88.
Thank you very much. I call Martin Whitfield to speak to Amendment 127 and other amendments in the group. Mr Whitfield.
I'm very grateful, Convener, and formally can I say good morning to the committee and those that are attending. Within this group, I predominantly want to talk to 127, 128 being a consequential, and also by doing so, I look forward to the Minister, who I know both has an amendment to move within the section, but also the Minister's slot to find where the government is sitting in respect to a lacuna that exists within the law that circulates around the 16th birthday, in that if a young person before their 16th birthday sails off out of the care system, their rights for advice, assistance and support are far less than those who travel indeed on their 16th birthday or indeed the day after. My understanding, having spoken to people, this arose in the original or in the various original legislative slots for this, because when people were talking about children under 16, rather than contemplating late teenagers who bring their unique characteristics to the world, thought was more made of when babies who may spend a short period of time in care and then go back to families. So it seems to be a position that hasn't really been considered until this bill. And this bill is very specific in the way it's drafted, that there is a difference between there is a difference that occurs on that 16th birthday anniversary, which is both inconsistent, unhelpful, and quite frankly, I'm not sure is what anyone expected until the reading of it was done. So the purposes of these amendments are to clarify that problem, and 128 is a consequential amendment that would be needed. But it will be interesting, and I look forward to hearing from the Minister with regard to their proposals if they have others to solve this problem. I'm grateful, Convener.
Thank you. I call the Minister to speak to Amendment 5 and other amendments in the group. Minister.
Thank you, Convener. I'll speak to my own amendments 5, 6 and 86 first. These amendments are all related and are needed to deliver quality care for young people in a well-planned way through the gradual rollout of aftercare. Amendment 5 would ensure that the expansion of aftercare to formerly looked after children who ceased to be looked after before the age of 16 is both affordable and deliverable. Stakeholders have indicated concerns around the pressures that the expansion of aftercare may place on children's services in terms of staffing and resourcing. I understand the need to be given time to adjust to increased numbers of children and young people requesting and receiving aftercare support, so that this does not impact on the quality of support for them or the support already offered to children and young people currently receiving aftercare. My Amendment 5 would allow for such expansion in a managed way. Amendment 6 is a technical amendment to give Scottish Ministers the power to accelerate the expansion of the new eligibility for aftercare to older age groups in the future by specifying a date that is earlier than the date of commencement of Section 1 of the Bill. And just in response to Ms McCall's request, I see no issue with that being through the affirmative procedure. Amendment 86 is also a technical amendment to allow for maximised accessibility of Section 29 following commencement. It is required for the same reasons set out in Amendments 5 and 6, and I would hope that members can support all of these amendments. Now, I'm concerned that Ros McCall's Amendment 88 would be detrimental to the delivery of aftercare for young people leaving care between the ages of 16 and under 19, because it places a duty on local authorities to provide aftercare for care leavers who do not need it or want it. Now, we have consulted extensively with young people and young adults in relation to aftercare provision, and they have at every stage emphasised the importance of their voice being heard and respected in decisions which affect them individually and in the policy decisions that are made nationally. Creating additional provision for aftercare in this bill is not the best route to ensuring through care and aftercare teams are able to support those whose welfare does require it. I think the best way to provide that clarity would be through strengthened guidance, and Government is already working with stakeholders to do so. So I would hope that this reassures Ros McCall that she will not press Amendment 88, and if pressed I would ask members not to support it. Now, Martin Whitfield's amendments 127 and 128 would also have the potential to negatively impact the delivery of aftercare for children and young people between the ages of 16 and under 19 who left care prior to their 16th birthday. Aftercare by design is an approach which recognises the importance of relationships and puts the needs and the well-being of the young person at the very centre of the support that they receive. Section 1 seeks to promote a rights-respecting approach, including for young people who choose not to approach local services upon turning 16 or who choose to make an approach at a later time. Now, I absolutely recognise the importance of ensuring that information about aftercare is clear, with good signposting to ensure that young people know their entitlements. There's a place for advocacy in there as well. As outlined above, work is underway to expand and strengthen the guidance on aftercare, including to support the changes that we're making through the bill. The guidance will... Yes?
Martin Whitfield.
I'm very grateful to the Minister for taking an intervention. Does the Minister accept that the bill creates a difference for young people leaving before their 16th birthday and leaving after their 16th birthday? And the purpose behind my amendment is to even the playing field for all of those young people who leave care.
Minister.
But I think I've already outlined some of the concerns that I have with this approach, and I've been very clear. You know, I do recognise the importance of ensuring that information about aftercare is clear, and as I've outlined, work is underway to expand and strengthen the guidance on aftercare. I believe the provisions that were taken through in the bill improve the rights of aftercare for children and young people who have been previously looked after. And the guidance that's been developed will continue to promote the need for collaboration to ensure that a person-centred approach is delivered, acknowledging every young person's journey is different. So I hope that reassures Mr Whitfield, but I'm assuming from his intervention it does not.
Martin Whitfield.
I'm grateful for the Minister's patience with regard to this, but in her submission she talked very specifically about those children over 16. What I'm talking about is those children who leave care before their 16th birthday, and the fact that there is a difference that exists. And I respect and understand the discussion about guidance, but fundamentally there will be a different statutory requirement placed. And as we've heard in other submissions, it's probable that it will be approached differently.
Minister.
I'd be grateful if Mr Whitfield could clarify further. Is he referring to the assessment in relation to children and young people who have left care prior to their 16th birthday coming back for aftercare?
Happy to say, I'm grateful to the Minister for again taking a third intervention. Indeed, the provision is that the provision as described in the statute is if the young person leaves under 16, they're effectively entitled to an assistance, whereas if they leave after 16, it's assistance and more. And the challenge is that if they leave, unless they fight hard and stay in until they're 16, they have less rights. And that, in turn, potentially will lead to a UNCRC claim of a differential that's being applied to the young people.
Minister.
I would respectfully disagree with Mr Whitfield on this point. I believe that the assessment that will take place, will take into account that every child's needs will be different, that the support will have to be provided based on that individual child's needs. So I don't believe that there will be any less, or I don't believe that they will have any less entitlement. It will be what that child or young person needs to be supported. I'm happy to take, given the concerns Mr Whitfield raises, I will look at this again ahead of stage 3, but I believe that what I've laid out is the position and is my position. Okay, so moving on. So amendments 89 and 90 in the name of Ros McCall remove the upper age limit for those currently eligible to apply for aftercare and give local authorities the discretion to determine the age range within which people may apply for aftercare. And my concern with these amendments is that they would create inconsistencies in different local areas for what we are trying to establish as a national entitlement. The same for young people who need and would benefit from aftercare no matter where they live in Scotland. These amendments might also have unintended consequences that affect the aftercare support currently received by young people with care experience. It is possible that some young people who are currently eligible by virtue of their age to apply for aftercare may no longer be able to if a local authority determines that they don't need it. The spirit of aftercare is to support young people with care experience as they transition into adulthood, to provide them with the tools and support they need to be successful, independent adults, and local authorities do already have the power to provide aftercare beyond age 26 and do already use that power. I think there's a danger that opening up aftercare to anyone over the age of 16 who was ever looked after could put real unforeseen pressure on children's services, rendering them perhaps unable to provide aftercare to the young people with care experience who most need the support while transitioning to adulthood and for whom this support at Section 1 of the bill was designed. I think there's also more appropriate routes for adults with care experience to seek support through adult services, through trauma-informed services, lifelong advocacy and more that don't necessarily involve pulling them back into the care system. So I therefore can't support amendments 89 and 90. Ros McCall's amendment 91 might have a similar effect insofar as some young people who are currently eligible for financial support and assistance towards expenses or of education or training may no longer receive it, as it will be up to local authorities to determine the upper age limit for support based on an individual's needs, including children and young people who are currently receiving this support. And the same arguments apply around inconsistency and differential treatment as for amendments 89 and 90. I'm conscious of how important financial support like the care leaver payment, the job start payment, the care experience education bursary and the summer accommodation grant is in helping care experience children and young people thrive. I propose to look in more detail for stage 3 at how local authorities can complement this support for those in receipt of aftercare using section 30 of the Children Scotland Act 1995. I therefore would ask Ros McCall not to move her amendment at this time. Convener, I would be very grateful if I could listen to Jeremy Balfour's comments.
I'm sorry, Minister. The procedure is you can speak to Jeremy Balfour's amendments, even though he has not spoken to them yet, but I have to take them in the order.
That's fine. Thank you. I thought I would ask. I understand the rationale behind Jeremy Balfour's Amendment 7, and I do thank him for his amendment, which allows us to debate these issues. Now, the landscape surrounding transitions is complex, and young disabled people, particularly those who are moving on from care into adulthood, face multiple challenges. Now, aftercare already includes support for health and wellbeing needs, including any needs arising from disability. Currently, young disabled people leaving care from age 16 who need and want aftercare have the right to an assessment of their needs and a plan to meet those needs. Through the bill, this right will be extended to more care experienced disabled children who left care before the age of 16 from their 16th birthday. Now, the type of aftercare advice, guidance and support required and the way that it is provided will be specific to a young person's needs. Any assistance by way of accommodation must have regard to the suitability of that accommodation to meet needs arising from any disability. Only those young people who were looked after by social work would be eligible for aftercare, meaning that the vast majority of young disabled people would not be eligible for this support. Now, I share in Mr Balfour's ambitions in seeking to improve transitions for young disabled people, but I don't necessarily consider that making further provision in respect of aftercare is the best way to achieve that. Now, the Scottish Government in COSLA published the National Transitions to Adulthood Strategy in June 25 to improve transitions to adulthood for all young disabled people in Scotland, including care-experienced young disabled people. The strategy emphasises that improving transitions needs a coordinated, collaborative approach which integrates the efforts of all relevant sectors and partners for all young disabled people and not just those who are care experienced. This group of young people is one of the most vulnerable groups in society, and I really do welcome all discussions around strengthening the support that they are given. If Mr Balfour agrees, I propose to look at this in more detail ahead of stage 3, including to see if there is more work that we could do in a non-legislative space to address these issues. So I would ask that he doesn't move his amendment. In summary, Convener, I encourage members to support my amendments 5, 6 and 86 and to vote against Amendment 88 if it is pressed and all other amendments in this group if moved.
Thank you. I call Jeremy Balfour to speak to Amendment 7 and other amendments in the group. Mr Balfour.
Thank you again, Convener. Convener, as a teenager boy, I remember a conversation a long time ago, in a previous century. I remember my father been approached by another parent with a disabled child, and they said their child was younger, and they said, what one piece of advice would you give to another disabled parent? And my father, without thinking, said, never take no as the first answer from a medical professional. Now, my father was an educated professional who could stand up to most individuals. I was very fortunate that I had 2 loving parents, supportive siblings, a good school that supported me through my teenager years. But as I've spoken to many more disabled people and disabled charities over the last 9 years being here, I think I'm the exception, not the rule. And that is particularly true for disabled children who are in some form of care, need and relationship. And Amendment 7 seeks to ensure that all disabled children receive appropriate support from their local authority to assist their transition into adulthood. It shouldn't be pushed earlier than is necessary, and that is happening a lot. I've spoken to a number of charities and children and those looking after children, and there's a real concern that disabled children are being moved into adult services too early and earlier than non-disabled children and counterparts are happening. That is because it seems to be easier to manage from a professional perspective, not from a child perspective, but from a professional perspective, the child's case. Due to pressure on social workers, disabled children are taken off orders quicker than they should be, and they don't get the same level of advocacy either. These children with this disability are perhaps the most vulnerable people within the system. And at the moment, many of them are not getting the transition they require, either in the way that they want it to happen or in a way that would be best for them. I think we would all agree, in principle, that disabled children should not be treated any differently than any other child of their age. And this amendment would simply put that into law. I hear what the Minister is saying. I do think there needs to be some statutory backbone to this. It's not simply enough to do it through guidance or policy documents. But in the light of what she has said this morning, I am willing to not move this amendment today, seek further discussions with her before stage 3. But I would seek to bring this amendment back at stage 3 if those conversations proved unsuccessful. Thank you, Convener.
Thank you. I call Willie Rennie.
I just want to make it clear that in respect to Martin Whitfield's amendment, The Minister is aware that the Promise have indicated support for 127 and that they do believe that there is a gap that needs to be rectified. So I'm puzzled as to why the Minister is so firm in opposition to Martin Whitfield's quite reasonable amendment, because if there are young people who leave care before they're 16, they will not get the support that they need. And so, I know the Minister probably isn't going to move today, but I would really appeal to her to have a discussion with the Promise, because they believe that the evidence that was given by Clan Child Law relating to how this is articulated, they have got concerns and they believe that they are valid, and therefore they are supporting Amendment 127. So I hope the Minister will take that into account when we come back at stage 3, because I suspect she won't change her position for today, but I am concerned that she's opposing something that the Promise are indicating support for. Yeah, certainly.
Minister.
So I did commit to Martin Whitfield, given our back and forth, that I would be happy to consider this again at stage 3. I would like to understand members' concerns. I know the Promise have concerns around this. There are a number of areas in the bill, of course. I don't think I've been firm on anything in relation to. I will take anything of great concern away to look ahead of stage 3. My position will remain the same, but I do give that commitment to discuss this further with Mr Whitfield and any other member who would like to discuss further.
Willie Rennie.
That their position will remain the same if she's open to discussion with Martin Whitfield. I don't want to be pedantic about this, but yeah, certainly.
Martin Whitfield.
I'm very grateful to Willie Rennie taking the intervention. I think what we have heard on the record is that the government's position won't change on this, but as always the Minister is very reasonable and often indicates a desire to speak about things. But in relation to this amendment, my understanding is the government's position won't change on it, but they're happy to talk about it, which may indicate what I will do in a few minutes.
It's a unique form of negotiation to say we can talk, but I'm not going to move.
Intervention. I am saying
Minister.
to a lot of amendments today that I will not be supporting them at stage 2, but I'm happy to discuss further at stage 3. I don't believe that is a unique approach. Just to clarify.
If she's saying that's the position today, is to say that she will oppose, that's fine. But I do hope there's flexibility when it comes back to the discussion. I'll conclude on that point.
Thank you. I call on Rose McCall to wind up and press or withdraw Amendment 88. Ms McCall.
Thank you, Convener, and thank you, first of all, to the Minister for agreeing to move that to Amendment 6 to the affirmative. That's very reassuring to hear. I think any changes that come to varying age and varying what we can offer, it's important that it has the scrutiny required. When it comes to my amendments, I'm going to try and give an idea of where I'm coming from here. Who is the parent of care-experienced children? I've personally went through a horrific year last year. I had to go home. For me, home was my mum. I'm 56. I managed to go back to an environment that I knew and I understood because it was there for me. When we're talking about care-experienced people, their home varies, their parents vary. Who they can rely on varies. And this bill is in some way trying to blend child services and adult services. That's why the Minister is looking at utilising IJBs. So aftercare cannot be a hard line. It cannot be a hard line. We have to look at a way of moving things forward in this country that people who have gone through a care system can always go back to find the support and help they need, because that's who their parents were. And that's what my amendments are trying to do. Now, I'm not going to press these today, because I'm going to go back and I'm going to work on them and see what we can do for stage 3. But if we are really serious about what it is we are trying to achieve as we move forward, we have to accept where care-experienced children are and what they need, and hard lines don't do that. So I will not press my amendments today. So I'll withdraw them and bring them, reserve the right to bring them back at stage 3. Thank you.
Thank you very much. Rose McCall seeks to withdraw Amendment 88. Does any member object? No member objects, so Amendment 88 is withdrawn. I call Amendment 127 in the name of Martin Whitfield, already debated with Amendment 88. Martin Whitfield, to move or not move?
Move.
The question is, Amendment 127 be agreed to? Are we all agreed? We are not agreed. There will be a division. Those in favour of Amendment 127? And those against? Thank you. The result of the vote on Amendment 127 is yes 5, no 5. As the outcome of the division is tied on Amendment 127, I will now use my casting vote as convener in order for the committee to reach a decision. I vote in favour of Amendment 127 and therefore Amendment 127 is agreed. I call Amendment 89 in the name of Ros McCall, already debated with Amendment 88. Ros McCall, to move or not move?
Not moved.
I call Amendment 128 in the name of Martin Whitfield, already debated with Amendment 88. I remind members that if Amendment 128 is agreed to, I cannot call Amendments 5 and 90 due to pre-emptions. Martin Whitfield, to move or not move?
Move.
The question is that Amendment 128 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 128? And those against? Thank you. The result of the vote on Amendment 128 is yes 5, no 5. As the outcome of the division is tied on Amendment 128, I will now use my casting vote as convener in order for the committee to reach a decision. I vote in favour of Amendment 128. Therefore, Amendment 128 is agreed to. I call Amendment 6 in the name of the Minister, already debated with Amendment 88. Minister, to move formally?
No. Not moved.
The Minister is not moving Amendment 6. OK. I call Amendment 91 in the name of Ros McCall, already debated with Amendment 88. Ros McCall, to move or not move?
Not moved.
Thank you very much. I call Amendment 92 in the name of Ros McCall, group with amendments as shown in the groupings. Ros McCall, to move Amendment 92 and speak to all amendments in the group. Ms McCall.
Thank you very much again, convener. And again, I'm going to start by speaking to my amendments in the group. Amendment 92. Now, this amendment replaces Section 1. And it's a biggie, because the current structure is fragmented and overly complex. It's, at its core, the support provided should be based on individual needs of the child at its centre. The current system doesn't facilitate that, and this amendment seeks to make changes to that effect. It brings the legislation in line with UNCRC. As the Parliament has ratified the incorporation of the United Nations Convention on Rights of the Child, I think it's incongruous that the government doesn't bring forward legislation that applies with that. This amendment brings together the duties, applications, assessments and assistance into a single, coherent framework. And that matters because complexity in law often translates into barriers in practice. So for young people leaving Clare, clarity is not a luxury, it is essential. This amendment ensures that they understand what they're entitled to, how to access it and how long it's going to last. And if we don't simplify and strengthen this section, I think aftercare will remain uneven, confusing and all too easily deprioritised. So Amendment 93, which looks at the financial support for education and training. This amendment restores the power to provide financial assistance for education, training, accommodation and maintenance, and it recognised that care experienced people are far more likely to face financial barriers when trying to progress. So in real terms, this can mean the difference between completing a course and dropping out, or the difference between independence and crisis. And finally, Amendment 94, I think this amendment is about making good law. Section 2 adds complexity without adding clarity or protection, so removing it streamlines the bill and avoids duplication and confusion. I believe that good legislation should be as clear as possible for those who must use it, particularly young people navigating systems that they didn't choose to enter. And those are my amendments. The only other amendment I want to speak to is 181, if I could maybe ask for some clarity. It seems to me that the member is suggesting an incorporation of a new body to run the register. I think that adds possibly another layer, another quango to the sort of myriad of what we have at the moment. So I would appreciate if the member could give me a little bit more in a submission as to what he is suggesting at this. Is it utilising a current system? Is it a new board? And how would that operate? And I would be interested in more information on that if I could. And thank you very much indeed, Convener.
Thank you. I call Martin Whitfield to speak to Amendment 178 and other amendments in the group. Mr Whitfield.
I'm grateful, Convener. And the block of amendments in my name fall into two. One, a substantial number running from 178, and then one that sits and stands on its own. But before getting into that, I would like to point out that I think it is incredibly beneficial but sad that we have a group of amendments that have to talk again about the UNCRC Incorporation Scotland Act, in this case restatement and application, because the Scottish Government, well, the First Ministers, the Scottish Government, Ministers and this Parliament have on numerous occasions undertaken to ensure that the UNCRC that we're all aware of and the struggle it was to get it onto the statute book would be respected, and that opportunities would be taken to bring Scottish law within that. The phrase bringing Scottish law within that is not as meaningful as the fact that it would open up a vehicle for all of our young people where they feel their human rights have been challenged or been taken away from them, to give them a vehicle to actually do what I genuinely believe the people of Scotland want, which is for a country, a legislature and a society in which young people's rights are respected. As a consequence of that not happening in the drafting of this bill, I have brought the amendments that sit before us between 178 and 184. And using the process that the Scottish Government have adopted in relation to UNCRC, its ability to restate and bring the provisions, in particular in this case over the situation regarding fostering, into the bill, so that young people who are affected by this can bring where they feel their rights have been challenged or indeed not fulfilled, give them the right to pursue this without the challenges and difficulties that exist in the minute, and have existed for a substantial period of time where young people wish to exercise those rights. So it is restating various aspects within the register so that the UNCRC applies. To Ros McCall's question about 181 and the new board, it's to allow the provision for an appropriate board, if necessary, going forward to hold the register. So we will all have been approached by individual fosterers and groups that represent the fostering community about the challenge they feel of receiving parity with regard to whether it is or it is not employment, parity with regard to payment and non-payment, and also the postcode lottery, indeed, of where the fostering family live in relation to where the young people coming into fostering go for. The purpose behind 181 is to allow something akin to the teaching register that would be held by a non-government body to represent and speak on behalf, but also to guide the entry, the retention and indeed the departure from the register. So it is a founding amendment that seeks to do that so that it can be applied within UNCRC. The final amendment that I'll speak to, Convener, is in respect of Amendment 217, which allows me to wear two hats, one with regard to post-legislative scrutiny, which I think is crucially important. It's something that I think, for the first time in the Scottish Parliament's history, in this session, we've started to recognise the importance of and have started to build into legislation. And again, with regard to my UNCRC hat on, this sunset clause will allow an impetus, I hope, because there is a strong agreement. In fact, I hope there's still a universal agreement that we will seek to comply with the promise by 2030. This sunset clause is a gentle indicator that that should happen, or there will be challenges that come at that period. If the sunset clause is required, I think we will be in a very, very sad and disappointing place in Scotland. But I still think, for the reasons of clarity and to incentivise, it should appear on the bill. I'm grateful, Convener.
Thank you. Minister.
Thank you, Convener. I understand the intention behind Ros McCall's amendments 92 to 94 and Martin Whitfield's amendments 179 to 184. They all seek to strengthen the protection of children's rights by extending the reach of the UNCRC Act compatibility duties. I've given very careful consideration to introducing the provisions on aftercare and the Register of Foster Carers as standalone provisions that separate this legislation from the 95 Act. However, I am not able to support the amendments in this group. As I have explained previously, the approach taken in the bill amending the Children's Scotland Act 1995 is deliberate and necessary to maintain coherence with the existing legislative framework governing aftercare and foster care. Reenacting these provisions as freestanding ones in this bill would introduce significant complexity, require duplication of related secondary legislation and risk fragmenting closely connected provisions across multiple acts. In relation to the Register of Foster Carers, the provisions are administrative in nature and do not substantively determine individual placement decisions, which will continue to be made under the 1995 Act. Yes.
Martin Whitfield.
I'm very grateful to the Minister for taking an intervention. There have now been a number of occasions where we have reached this point with regard to UNCRC, and the Government's approach has been it is just too difficult. The choice of answering the challenges that the Supreme Court levelled towards the legislation, and indeed the approach that was taken by this Parliament to ensure that that legislation went through, was founded on an understanding that the Government would use every opportunity to bring legislation within the UNCRC. Is that genuinely still the Government's intention, or are we just going around and around in circles and expecting our young people to eventually potentially have to go all the way to Europe to enforce these rights?
Minister.
I would disagree strongly with Mr Whitfield, and I would absolutely advise that it is still the intention. I have been clear in relation to the work that is going to be underway. I obviously announced, and I'm going to get onto this in my speaking note, but we have the review of the legislative landscape by Professor Norrie, and we have the work laid out in the Children's Rights Scheme. So I would say that that is absolutely still a commitment from the Government. The aftercare provisions in the bill amend sections 29 and 30 of the 95 Act. These provisions are closely connected to other parts of that Act. Piecemeal change, I think, would also add to the very clutter of the landscape that some, including the Promise Scotland, have raised as an issue, and make it harder for those who will benefit from these provisions, people entitled to aftercare, foster carers and children in foster care, to navigate the law, not easier. The Scottish Government's commitment to the UNCRC and to delivering the promise also underpins the commissioning of an independent review, as I've already stated, of the legislative landscape relating to the care system led by Professor Kenneth Norrie and CELSIS. The review is responding to the concerns that the current framework for care experienced children and young people has become complex and difficult to navigate in practice, and provides an opportunity to consider the concerns raised regarding the applicability of the UNCRC Act and whether restating existing laws more broadly might be more appropriate. The review will report later this year, and it will inform the next government on whether further legislation is needed and what other practical activity would help support children, families and those who support them as they interact with the law. And this is in addition to the commitments that we've made through the Children's Rights Scheme that was laid before Parliament in November, which includes a commitment to ongoing engagement with the UK Government to explore whether there might be a straightforward and effective way to ensure that key legislation that impacts children and young people is within the scope of the UNCRC Act. And I'd really welcome the support of members across the spectrum in finding that overarching solution. Now, subject to progress with that, the Children's Rights Scheme also includes a commitment to potentially reviewing key UK legislation in devolved areas to determine if reenactment is necessary to bring them within scope of the UNCRC Act. And it will be for the next government to decide how to proceed in light of progress made with UK Government and in the light of Professor Norrie's recommendations. And it is entirely possible that proceeding with a new children bill to replace some or all of the Children's Scotland Act 1995 will be one of the possibilities at that time. Certainly, such an approach would assist with both legislative decluttering and with bringing functions conferred by the 1995 Act within scope of the UNCRC Act. But committing to this now, while these other pieces of work remain in progress, would be premature. Martin Whitfield's... I Yes.
Ross Greer.
I'm grateful for that. I'm hoping the Minister can help me out here, because I am honestly struggling with what to do on this group, because I understand in the first instance that a lot of this is caused by the result of a Supreme Court judgment, which is obviously out with the Scottish Government's hands. It's also in part caused by the fact that a legislative review initiated by the government should have taken place long before now and hasn't. And we now have a bill in front of us with the government saying, well, there'll be a legislative review, it will conclude at the start of the next Parliament, and then the next Parliament, the next government will have to make a decision on that. I accept the Minister's point that this is not an ideal way to make law, that the amendments in this group by Martin Whitfield and Ros McCall. I accept that there would be additional fragmentation from that. What I'm weighing that up against is the fact that if we don't do this, then young people will lose the recourse that they would have by a UNCRC compliant version of these particular provisions in the bill. So the Minister said that it risks fragmenting provisions across different acts. Could the Minister specify what the practical negative effect of that would be for care-experienced young people and for others in the system? Because I'm trying to balance that up versus the negative effect that there would absolutely be of us passing a law that is in part not UNCRC compliant and therefore that loses them the ability to try to take action to receive redress via the provisions that the UNCRC allows.
Minister.
In relation to aftercare, the provisions are tied up with other aftercare provisions in the 1995 Act. In relation to fostering, decisions about the placement of children in foster care are still going to be made under the 1995 Act, and so outside of the scope of protections for children's rights in the UNCRC Act, which is why I'm saying that builds on that further fragmentation. I've laid out, and I absolutely understand where Mr Greer is coming from and other members in relation to UNCRC, but I have set out, and sorry, I should go back again and say, in terms of the timing, I do respect Mr Greer's comments around the fact that perhaps this should have taken place before now. We have work to build on. There has been ongoing work from the Promise Scotland in relation to the legislative landscape. That is exactly the work that this review by Professor Kenneth Norrie and Celsius intends to build on. I have laid out that clear plan in terms of that work and when that review will report back, coupled with what I've laid out in relation to the Children's Rights Scheme and the assurance that that process will take place. Obviously the engagement with the UK Government, but if we remain unsatisfied with that in terms of maximising coverage for children's rights, because Mr Greer is correct in what he said at the beginning, we wanted that my chosen way forward would have been to ensure those maximum rights across everything. So I think I've laid out a very clear pathway in terms of what the Government will do to ensure that these provisions fall within scope in future, but taking that with a number of other matters that need to be considered as well. And I think that is an appropriate way forward. I understand the temptation around this, around these amendments, but I do believe that it will lead to further fragmentation, and we are on a course in terms of resolving this once and for all. Yes.
Willie Rennie.
So the Minister set out, I would paraphrase it as, it would create an untidy landscape with fragmentation. But I've not heard there would be any disadvantage to young people, to carers, those with care experience. And if her plan for the Norrie review results in another bill in future, if this is untidy, she can tidy it up at that point. But now I think we need to try and make some kind of improvements, even if it is a little bit messy, in order to make sure we can give the best possible rights to care experienced people.
Well, I mean, I understand Mr Rennie's points. However, you know, I'm getting told over here that the landscape is too cluttered and too complex, and then I'm now being told this morning that, OK, we can add to that further. With I would say no real benefit. I mean, the practical impact of bringing aftercare provisions within UNCRC scope is very limited, because only 16 and 17-year-olds fall within that age range to which UNCRC requirements apply. Of course, aftercare extends to age 25, so there's a limitation there. I think proceeding on a piecemeal basis to bring individual provisions within UNCRC Act scope, you know, would quickly scatter what I've already referred to, the material across a number of acts, undermining that clarity and coherence that people are really calling for. And I think it just runs counter to the calls from stakeholders. And I've tried my best to provide assurance that the concerns relayed by the committee in relation to the scope of these provisions will be considered and will be reviewed in line with the work around the review of the legislative landscape and, if I could just finish my point, and the Children's Rights Scheme. And I hope that provides assurance rather than adding to the complexity of the landscape on a short-term basis.
Willie Rennie.
So the Minister has accepted there will be some improvement for some people in our contribution there.
Okay.
I think that's worth taking at this stage, even if it adds to further complexity, which can be resolved later on following the Norrie review. I would say that's worth it. Minister. Does she not agree?
I would, as I say, the difficulties with so many of these aspects of the Promise Bill are that I hear different calls from different stakeholders. So I would imagine that some people would agree with that, and I imagine that some will think that this will just complicate the landscape even further and could have a negative impact on children and young people. So I can't weigh up the benefits there. So I think that that's something that the committee, needs to consider. But I hope the assurances that I've put on record in terms of the work that government is going to undertake and the potential to look at, for example, as I laid out in my opening, a new children's bill which takes all of this in the round, which would be a much neater, and I think committee would agree, better way to proceed in terms of decluttering
Would
this.
the Minister give way?
Yes.
I'm grateful to the Minister for giving way. I'm just struggling to understand why we're at this stage at this point. Because in response to Ross Greer, the Minister accepted the government could have done this differently and earlier. There have been alarm bells raised about this from the very beginning, going back to when the bill was introduced. It featured heavily in our committee report because it came up time and time again in our evidence. So my question is simply, why didn't the government do more on this issue sooner, rather than complaining now or raising concerns now that members' attempts to rectify this are not perfect? But why didn't the government try to rectify this far earlier?
Well, as I've said, there has been... I'm not going to sit here and make excuses. I understand the point, and I appreciate the point that we could have embarked on this work earlier. I think there has been other work underway in relation to the review that the Promise were undertaking. And that was something that government had to consider, whether we felt that was full enough to continue to sort of begin on this path of reenactment, or whether that was something that would have to be built upon further. And I believe, through the review by Professor Kenneth Norrie, that is the position that we've taken. I obviously don't have to tell the committee about, the raft of work that is underway to deliver on the Promise. And, when I'm out speaking to children and young people, they're talking to me about things that they want to see change, and that's the things that the government have been moving on. My focus has been trying to deliver for real change for children and young people right here and right now. Decluttering of the legislative landscape is of course important for all the reasons I've laid out and for everything that the committee has been discussing this morning. But I would say that our attention has been focused on where children and young people have told us that they feel it's important to move. But, as I say, that's not taken away from the importance of this work, and that's why I've laid out the assurances that government will be moving on this further.
Is that you concluded?
I believe so.
Yep, no, that's great. I call Ros McCall to wind up and press her withdraw Amendment 92. Ms McCall.
Thank you, Convener. And that's been a very interesting discussion, and I've been very quiet listening to what's been going on. For me, Convener, I think we're, especially with these amendments and this group of amendments, we're sort of in a chicken and egg situation. We have a cluttered landscape, a legislative problem there, but not taking into consideration the UNCRC and adding another layer of clutter. We have to deal with the clutter, and we will deal with the clutter. So I accept the assurances, but that doesn't, to me, accept the fact that we do not make sure that this legislation, this piece of legislation, does not align with UNCRC to make that happen. So, having listened to that, I would like to press my Amendment 92.
Thank you. The question is that Amendment 92 be agreed to. Are we all agreed? No. We're not agreed. There will be a division. Those in favour of Amendment 92? Thank you. And those against? Thank you. The result of the vote on Amendment 92 is yes 5, no 5. As the outcome of the division is tied on Amendment 92, I will now use my casting vote as convener in order for the committee to reach a decision. I vote in favour of Amendment 92. Amendment 92 is therefore agreed. I call Amendment 93 in the name of Ros McCall, already debated with Amendment 92. Ros McCall, to move or not move?
Moved.
The question is that Amendment 93 be agreed to. Are we all agreed? No. We're not agreed. There will be a division. Those in favour of Amendment 93. Thank you. And those against? Thank you. The result of the vote on Amendment 93 is yes 5, no 5. As the outcome of the division is tied on Amendment 93, I will now use my casting vote as convener in order for the committee to reach a decision. I vote in favour of Amendment 93. Therefore, the committee agrees to Amendment 93. I call Amendment 94 in the name of Ros McCall, already debated with Amendment 92. Ros McCall, to move or not move?
Moved.
The question is that Amendment 94 be agreed to. Are we all agreed? No. We're not agreed. There will be a division. Those in favour of Amendment 94? And those against? Okay, the result of the vote on Amendment 94 is yes 4, no 6. Amendment 94 is therefore not agreed to. Go to 7.
Question is that
But that's only. Thank you. I call Amendment 7 in the name of Jeremy Balfour, already debated with Amendment 88. Jeremy Balfour, to move or not move?
Not move.
Thank you. I think that's probably a suitable time to take a break, so I will suspend the meeting for 15 minutes. Thank you. Thank you very much and welcome back. I call Amendment 129 in the name of Martin Whitfield, group with Amendments 130, 131, 132, 133, 134, 135 and 98. And I call on Martin Whitfield to move Amendment 129 and speak to all amendments in the group. Mr Whitfield.
I'm grateful, Convener. And again, if I look to the title of this group, I think it sums up very succinctly what we're looking at, which is the care services for young people continuing care, and most appropriately, the return to care and housing. And this is the group of amendments that deal with the transition and the realistic and unfortunately all too common situation where the transition are young people and becoming not so young people have challenges and the right in which to return to care. There are two amendments that I want to specifically talk to in this section, which is 129 and 130. 129 is based, interestingly, on the ONS data, which analysed young people across the UK and marked that the average age that they depart from their home is 24. So the current age of 21 is the upper age threshold, makes little sense. And indeed, and sadly, when we look at care experienced adults, we have a group who are twice as likely to experience homelessness, 1.5 times more likely to have financial issues. And taking away what we've already heard in earlier submissions on amendments from Ross McCall, what the idea of home is needs to be as important to our cared for community as it is to others. We cannot take their home away too early. Amendment 129 extends the upper age limit for continuing care to 26. And the reason for this is that it is very much an age in consultation with the sector and others that there is an agreement on a settling, a coalescence around that it's an appropriate time under which it is likely that individuals may suffer events that would cause them, if other than being in the care sector, to return home, but those in the care sector don't have the opportunity to do that. So my amendment extends the age limit for continuing care to 26. Amendment 130, and this I think will become an important element within this group, is the right to return to care. That strange thing that I'm sure many individuals who watch this, including myself, have discovered when suddenly their children return to their doorstep unexpected, and you do what every parent, what every carer wants to do, is open the door and welcome them back in. If we go back to the promise itself, they talked of young adults for whom Scotland has taken on a parenting responsibility. They must have a right to return to care and have access to services and supportive people to nurture them. In essence, encompassing that which all parents undertake to do to the best of their ability when their offspring return. I'm more than happy to give way to John Mason.
I thank the member for giving way. And again, I'm very sympathetic to what he's saying. Is there a problem, though, that if the care staff have completely changed in, say, a care home, then that's not quite the same situation as going back home?
Martin Whitfield.
I'm grateful for the intervention, and John Mason picks up on an element that is frequently discussed both by young people themselves, but also by those who work within the sector. I think we need to remember that the care sector is much, much wider than just care homes. That's not to take away the change of individuals. Even within our schools, I see young people who return to primary schools when they're 2 years into their high school, only to discover there are no faces that they know. But then that also speaks to something that the promise encapsulated, on my understand genuinely for the first time anywhere in the world, that there needs to be a concept of love. And if a young person returns to a care home and there are no familiar faces there, they should still expect that door to be opened and them to be brought in, because the world of corporate parenting isn't about individuals, although individuals are very important in young people's lives. It is about the moral drive that sits behind that. And it is a challenge. It is possibly a greater challenge than in a more usual family situation. unless the child returns home and discovers the parents have moved, which I've been tempted to do on a number of occasions. I think it is about trying to encapsulate, and I emphasise trying to encapsulate, but to achieve what sits behind the promise and has sat behind the promise since it was made all of those years ago, to try and create, to allow those that support our cared for community to offer the sort of support that you would see in your family home. I absolutely admit it's a challenge. I absolutely admit how you would define it, how you would teach it, how you would assess it could be a challenge. But if the last resort for an individual is to go back to a foster family that they haven't seen in a while, to go back to a care home that might indeed have closed and moved, to knock on the door and to have that door open, I think is very important. It is a very important signal that this Parliament can send. Yeah, take on again.
John Mason.
I'm sorry to intervene again, but he mentions a foster family. Would they have to take the person back?
Martin Whitfield.
And again, the situation, I think, depends in reality on what happens. If someone turns up at their door and they're capable, then absolutely, you know, I've spoken to a significant number of adults who take on fostering responsibilities, and they've all said exactly the same thing. Of course, they would open the door. Now, the reality is whether that would stay as the return to care going forward is a different question, because we're then into what we've talked about already today about what's right for the individual. What is it that's needed? What has caused the return? So in the immediate instance, you know, I would hope every person would put their hand out to someone who's in challenge, but that immediate could be opening the door, coming in and having a cup of tea. Whether the right to return to care is the right to return to the very specific situations you were in when you left care is a different argument that rightly needs to be had, because it has to be right for the individual, and then also has to be right, to go back to the UNCRC, for the human rights of other individuals that are sitting within that environment at the time. We have a skill, where the legislation allows, we have a skill set to deal with that.
Jackie Dunbar.
Thank you. And it's on the question that John Mason was asking, and I'm not clear yet, and I don't know if you've came to it yet. Are you saying that for foster parents in the future they have to sign up that they have to open the door, 20 years down the line, maybe, or even more? I'm genuinely not clear if that's what you're suggesting or not, because then that would. I'd be worried there in case it would stop foster parents coming forward.
Martin Whitfield.
I apologise to Jackie Dunbar for cutting across there. That's not what is being proposed here. What is being proposed is the right for an individual to return to that environmental system that we call care. The environmental system that we call care, it may be a return to a foster family that they previously were with. It may be in an emergency, the door opening and a cup of tea while contact is made and a different situation has arisen. It is impossible in any situation for someone to return to a previous time and have exactly the same support. I mean, we know in our own, when you redecorate your child's bedroom and when they go away and then come back and go, I don't like the wallpaper, they're not entitled to have their old wallpaper back. But that's not what they seek, and that's not what the purpose behind all of these amendments that have been proposed, and indeed this section, is about. It is about that system that says to an individual, you are not abandoned, you're not thrown away just because you are care experienced. You have a right to return to care. Not an absolute right to return to the absolute care package, the care environment that you had when you left, because potentially they may have been much, much younger. To talk about the 20 years difference, you're effectively then therefore talking about a child who potentially leaves a care system at 6 or 7. But they have a right to, if I may just finish this point, they have a right to return to that system that we call care, that is being which is being redefined by that which underpins the promise, which is, as we've already talked about, a very, very small number in actual fact, but they should have the same expectation from their parent, be it a corporate parent, that individuals also have from their own parents. Sorry.
Miles Briggs.
Thank the member for taking this intervention, and I think there's a lot of sympathy for what the member's trying to achieve. In North Yorkshire, there's a core offer for care leavers, which brings together likely information which people would access around accommodation, health, relationship support and job opportunities. Is that what he is envisaging, kind of these amendments then providing, that there's no wrong door for someone to go to and then access to information?
I think the phrase "no wrong door" is a very useful one, and it also sits. We have amendments coming down the line about responsibilities with regard to corporate parenting, and I think it is a situation that needs to be looked at as a whole, and it has been a challenge that's been articulated by lived experienced carers across the board and predating this bill and almost, well, from the start of the investigations with regard to the promise. The fact that there is this cut-off after which they no longer feel attached to what others would call their family, and what we've heard about is home. Now, what home is to individuals is a very subjective and very different analysis, and I like the concept of no wrong door, so that the right advice can be put there. So in relation to my amendment 130, as stated, young adults from Scotland have taken a parenting responsibility, and I think that's a really important element of this, whereupon Scotland has undertaken that parenting responsibility, must have a right to return to care and have access to services, to supportive people. That talks about who opens the door to John Mason's intervention, to, and then the most important element of all of it, nurture them. And with that, I move my amendment.
Thank you very much. I call Nicola Sturgeon to speak to Amendment 131 and other amendments in the group. Ms Sturgeon.
Thank you, Convener. I will speak to Amendments 131, 132, 133 and 134 in my name. Let me say at the outset, I also support the intention of amendments in the name of Martin Whitfield and Willie Rennie, although I believe that my amendments more effectively achieve the objective of incorporating a statutory right to return to care. I think Amendment 98 in the name of Ross McCall is a complement to my amendments, and I think I would support that too. In starting to introduce these amendments, I want to take a step back and I suppose really answer the question, what is the promise in a nutshell? And when people ask me that, the answer is that an important principle of the promise was always to ensure that young people growing up in care get the same support from their parent, which is the state in its various forms, as other young people would get from their own families. And it is a really important part of any young person's life when they make that transition from childhood to adulthood. We all know that it can be a difficult, often a gradual, and very often a non-linear process. And as Ross McCall just commented in an earlier group, you can be well into adulthood and still have the need to return to your parental home. Those who grow up in care should have that same right, and that's at the heart of the amendments in this group. Let me just turn to each of the amendments. Amendment 131 strengthens what is an existing duty in Section 25 of the Children Scotland Act 1995 by making it explicit that any child under 18 who is homeless or living in accommodation that is not suitable for their welfare must be accommodated as a child. And that is intended to deal with the issue that often 16 and 17-year-olds, particularly those with care experience, if they find themselves homeless, they are routed through homeless services, not through children's services, and I don't think that aligns with the promise. Amendment 132 changes what is currently a discretionary power to provide accommodation to care experienced young people aged 18 to 21 into a mandatory duty where accommodation is needed to safeguard or promote their welfare. Amendment 133 ensures that young people who return to care or accommodation are eligible for continuing care on the same basis as those who never left care. And that amendment also allows continuing care to be provided in alternative accommodation where staying in the original home is not possible. Yes.
John Mason. I think she's kind of answered just what I was going to say, which was how would this tie in with a foster care situation? Because there might be new foster kids and there just wouldn't be accommodation available.
Nicola Sturgeon.
Very strongly agree with Martin Whitfield's response to that question. This is about a duty on the system to provide the ability of a young person to return to care. You know, all of us who grew up in loving families, you know, if we return to that environment, as Martin Whitfield said, it might not be identical. We might not be able to get exactly the same love and care that we got years previously, but the ability to have a return to that environment is what these amendments seek to incorporate, and I think that is important. In terms of Amendment 133, that is dealing with what is currently a gap in the current system. Currently, young people who return to care can actually lose access to continuing care entirely, and that creates one of these cliff edges in support that I think we all recognise we need to deal with. And finally, Amendment 134 creates, and I think this is really important, it creates a discretionary power, and I want to stress the word discretionary, for local authorities to continue providing continuing care up to age 25, where this safeguards or promotes a young person's welfare. It doesn't impose a blanket duty, but it does allow flexibility where young people might not be ready to move on from care at age 21. And again, I think that encompasses this notion that a care-experienced young person should have the same support at different stages of their life as most of the rest of us are able to take for granted. Finally, Convener, I will listen carefully to the Minister's response, obviously. I want to be clear, though, that I am very strongly minded to press these amendments today. I recognise they may need further work ahead of stage 3, but so important, I think, are these amendments to the final package that this bill represents, that I have a strong desire to see us put these commitments into the bill at stage 2, and then by all means work to improve any flaws ahead of stage 3, then leave this gap at this stage in the hope that we might do something at stage 3. So that's why, subject of course to listening to the Minister, I am very minded to press these amendments this morning. Thank you, Convener.
Thank you. I call Willie Rennie to speak to Amendment 135 and other amendments in the group. Mr Rennie.
So my Amendment 135, I've been working with a previous witness to this committee, Duncan Dunlop, who spoke very powerfully about his experience and his advice. He drew attention to what Miles Briggs talked about, was the North Yorkshire Council's approach. And whatever we do, the legislation needs to say very clearly that we're always here. And that's what they've done in North Yorkshire. Because people won't have the time to read legislation, they won't have the time even to read guidance or advice sheets. They just want to know, is the system going to be there for them when they need them? And so all of these amendments and others are aimed at trying to provide that collective assurance to people that we always will be here. So my amendment 135 in particular seeks to give young people who leave care prematurely the right to return to a place of safety and belonging, recognising that a child's need for care does not end on their 18th birthday. A child or young person who has been looked after by a local authority for a cumulative period of at least 6 months at any time before their 18th birthday shall have the right to request the right to return to care at any point up to their 21st birthday. And I'll leave it at yes.
John Mason.
I thank the member for giving way. I'm now in a position where I'm confused because I've got Martin Whitfield's amendments, I've got Nicola Sturgeon's amendments, I've got yours, and I'm sympathetic to them. But are they alternatives to each other? Is it yours or Nicola Sturgeon's or Martin Whitfield?
Yeah,
Willie Rennie.
I am prepared to be pragmatic about all of this. I recognise there are competing alternatives, and that's why I'm keen to hear what the Minister's saying before I decide whether I'm pressing or not.
Thank you. I call Ros McCall to speak to Amendment 98 and other amendments in the group. Mr McCall.
Thank you, Convener. This has already been a very interesting discussion because we've broached on this before. I very much in agreement with the statement, no wrong door, as was mentioned by Miles Briggs. For me, my amendment 98, I believe that housing is a foundation. It's not an afterthought. We cannot talk about well-being or education or employment without having housing into the mix. And I agree with Ms Sturgeon because the process currently is that is looked at as a homeless issue rather than a continuation of care. And I think that is the fundamental point of this. This amendment requires a sort of statutory guidance to improve access to secure and suitable housing for care-experienced people. In real life, housing instability is one of the biggest drivers of crisis, homelessness and disengagement from services. I've tried already to bring forward an amendment similar. I used the housing bill for that. I was very politely informed at the time that that was the wrong avenue and it should be put forward through an education bill or a care experience bill. And I am taking the government on its word, and I have brought this forward. So I respectfully ask the Minister and the committee to finally support the housing needs that I believe the promise lays out. In general, with the other amendments, if I just make a quick comment to Mr Mason and Ms Dunbar, when it comes to foster carers, as much as that is the person that was assessed to be the right support and care for an individual at a time, I don't believe any of us are stating that any foster carer needs to therefore step up, because the assessment would be different of anybody returning. The needs would be different, the desires, the hope and what support would be required would be different. But I have spoken to many foster carers in the course of this job and this process and over the years, and every single one has stated to me that care does not end when the placement ends. Absolutely.
Jackie Dunbar.
Just for clarification, I totally understand that and I totally agree with it. My fear was that we were maybe going to be putting pressure on future foster carers, that they would have to, when, as you say, there's no have to about it normally. And that was what I was trying to get out, because what I would not want is for us to stop or discourage people coming forward for foster care. And so it genuinely was just for clarification.
Ros McCall.
Thank you very much for that. And I do accept that concern. I'm sure we're going to be speaking about foster carers further on in this process, and anything that might cause a concern about making sure that foster carers continue to come forward, because they are such an integral part of this process. But this is, as has already been stated, is a right to return to care. And we have to have that door open for care experienced people, and that's what my amendment is trying to do. Thank you, Convener.
Thank you. Minister.
Thank you, Convener. Convener, I thought it would be helpful to set out the Scottish Government's policy position on continuing care and aftercare to help explain my position on the amendments to help clarify. Continuing care and aftercare policies are tailored to support a successful transition into adulthood and independent living for young people who have been looked after in Scotland. As members will know, there is a range of statutory provision through primary and secondary legislation on both policies. The Government's focus on this bill has been to strengthen implementation so that fewer young people leave care too early, so that the need to return to care is reduced, and so that young people are fully supported when they do leave care. Now, continuing care enables young people to remain longer in the place they've called home and ensures they can progress in life at their own pace. Aftercare is the next step in offering independence through interdependence to help them continue to build the skills and resilience they need as they become young adults. Aftercare also supports young people who have been looked after at home from the time they leave care for those who want and need it. I absolutely recognise that transitions are not linear and that some young people may seek to come back to their local authority for support after a period of independent living. This is something which Aftercare does support and which the bill extends to a wider group of care-experienced children and young people. And existing legislation does enable local authorities to provide aftercare, as we've already discussed this morning, beyond age 26 where appropriate, but of course it remains a children's services-led support. Many care-experienced adults or otherwise vulnerable adults' needs are better supported through trauma-responsive, universal and targeted adult services. However, I hear loud and clear the concerns both from members and from those of stakeholders. Moving on to members' amendments, Martin Whitfield's Amendment 129 would extend continuing care up to the age of 26 and enable young people to return to continuing care after they have decided to leave. I'll come back to some of the bulk of this in a second, but I do accept that there is a need for more consistency on allowances for continuing care, and can advise that the Government will work with local authorities and other stakeholders to provide clear guidance on this matter. As drafted, Amendment 130 would create a right to return for young people who cease to be looked after or subject to a kinship care order, extending from age 16 to an upper limit that is yet to be specified, with specific provisions on accommodation by children's services, when other services and provisions would be far more suitable, perhaps for their age, stage and circumstances. Now, I welcome Nicola Sturgeon's very careful consideration of how young people can be better supported out of care and into adulthood. I've considered all members' amendments in this group very carefully. I think we've already had a question from Mr Mason in terms of the similarity of some of these amendments and what they intend to achieve. And I think at the end of that, it is essentially that we want to ensure that young people young care experienced people are supported in every way that they should be. So I've considered all members' amendments in this group, and while I do believe that further work will need done ahead of stage 3, Government will support amendments 131 to 134 in the name of Nicola Sturgeon. I believe that this is a package that most closely aligns with the Government's preferred overall approach. I think it would be good to have further discussions ahead of stage 3. For example, there's some clarity still required. It would be helpful to understand whether you intend to give local authorities a power to provide different accommodation to young people if the original accommodation is no longer available up to age 25. There's some other questions that I have around that, but I think that that's something, as I say, Government is intent to support those today. I would ask other members not to press their amendments in this space, but I would be more than happy to discuss or continue discussion with this. Members will be aware we already have meetings set up in relation to discussing further points of the bill. Now, Ros McCall's Amendment 98 would add care experienced people to the reasonable preference categories for social housing allocations. Care leavers already have reasonable preference if they are homeless or threatened with homelessness and have unmet housing needs. The Scottish Government's practice guide on social housing allocations sets out that landlords will want to consider awarding priority to looked after young people. I recognise that there are challenges that care leavers encounter with their housing situations. I intend my officials to refresh guidance for local authorities and corporate parents around this, improve information on financial support available, and to continue engagement with the Department for Work and Pensions on how young people leaving care access their services in Scotland. But I believe that it came up previously when it was debated under the Housing Bill. This amendment gives rise to a risk of discrimination under the Equality Act or in terms of ECHR Article 14, elevating the needs of care leavers above those fleeing domestic abuse or leaving prison, as just two examples. And it's not obvious how this would be objectively justified for the purposes of Article 14. So I would urge members not to press their amendments, other than, as I said, the amendments that I have intimated Government will support, which is amendments 131 to 134.
Would the Minister give way?
Yes, of course, Convener.
I'm just wondering, and normally if the Government want to see something improved or clarified before stage 3, they would ask the member to not push it at stage 2 and then bring it back, a revised amendment at stage 3. Is that not the normal practice, and why are the Government not taking that approach today?
Maybe the normal practice, Convener. You know, I think I've been clear. I've heard very strong calls from the committee around the need for continuing care and that right to return. This is the approach that I have taken, and as I say, much in line with all the other conversations I've had this morning around continuing discussions ahead of stage 3. That's exactly what I'm planning to do with Ms Sturgeon in relation to these amendments.
So would the Minister give way again?
Yes.
So can I just clarify, Is it the Minister's view that if Ms Sturgeon's amendments are passed at committee today, they will not be the amendments and the same wording that would be in the final stage 3 vote for MSPs to determine? Or is the Minister's view that the wording is okay, but there needs to be more discussion about it? I'm just a bit confused what we are, as committee members, are being asked to support if the Minister herself is saying the government wants to see changes to it.
I can't confirm that today. I would imagine that there may be small tweaks required, as there is usually, and like what I've said to other members around those amendments that haven't been pressed. As I say, that this is the position I'm taking today. I don't think it's far off, some of the other conversations that we've had this morning. Yes, I will take them into account.
Can I be very clear from my part? If the final bill at stage 3, the bill that Parliament is asked ultimately to vote on, contains the amendments as they stand right now, I would be perfectly happy with that. What I am indicating, and I think it is reasonable, that if the government think these amendments can be improved in some way, then I am open to that discussion. That would then be for the Parliament as a whole to judge when it sees the stage 3 amendments.
Minister.
I have nothing further to add. I'm looking to strengthen these provisions in any way that I can. I believe there is cross support for these provisions across the committee, and I'll work to make that as strong as they possibly can be.
Thank you very much. I call Martin Whitfield to wind up and press or withdraw Amendment 129. Mr Whitfield.
I'm very grateful, Convener, and to echo Ros McCall, perhaps from the other end of the debate, this has been a very interesting section. I am glad that the Government accept that on the face of the bill and at stage 2, we need the right to return to care. We need discussions about continuing care. And I welcome the, if perhaps late in the day, confirmation of where the Government stands on this. I think it is important that we have amendments on the face of the bill at stage 2 that can be worked on. I have some concerns about the amendments that the Government have agreed to support as to their extent, and again also, as always in my case, with regard to the UNCRC. But given the Minister's guarantee of discussions on this, but on the basis that the bill will be amended today, I will seek to withdraw my amendment and not press the second one.
Thank you very much. Martin Whitfield seeks to withdraw Amendment 129. Does any member object? No member objects. Amendment 129 is withdrawn. I call Amendment 130 in the name of Martin Whitfield, already debated with Amendment 129. Martin Whitfield to move or not move?
Not moved.
I call Amendment 131 in the name of Nicola Sturgeon, already debated with Amendment 129. Nicola Sturgeon to move or not move?
Moved.
The question is that Amendment 131 be agreed to. Are we all agreed?
Yes.
That is agreed. I call Amendment 132 in the name of Nicola Sturgeon, already debated with Amendment 129. Nicola Sturgeon to move or not move?
Moved.
The question is that Amendment 132 be agreed to. Are we all agreed?
Yes.
That is agreed. I call Amendment 133 in the name of Nicola Sturgeon, already debated with Amendment 129. Nicola Sturgeon to move or not move?
Moved.
The question is that Amendment 133 be agreed to. Are we all agreed?
Yes.
That is agreed. And I call Amendment 134 in the name of Nicola Sturgeon, already debated with Amendment 129. Nicola Sturgeon to move or not move?
Moved.
The question is that Amendment 134 be agreed to. Are we all agreed?
Yes.
That is agreed. I call Amendment 135 in the name of Willie Rennie, already debated with Amendment 129. Willie Rennie to move or not move?
Not moved.
Thank you very much. I call Amendment 95 in the name of Ros McCall, grouped with Amendments 136, 137, 138, 140, 141, 166, 169, 221 and 224. Ros McCall to move Amendment 95 and speak to all amendments in the group. Ms McCall.
Thank you, Convener. Yes, again, I'm going to speak to Amendment 95, which I believe aligns Section 3 with the needs-based approach. The child is meant to be at the centre of this process, and that applies if assistance is needed or should be in the background. Having a process where the person's individual needs are not accommodated does nobody any favours. So this amendment seeks to not only broaden the age range, but allow local authorities the flexibility to ensure that the needs of the individual is met at its centre. So I believe that consistency matters. So this amendment ensures that Section 3 reflects the same needs-led principle that's applied elsewhere. Without it, we risk sending mixed messages about who qualifies for support and why. I am not going to talk to any other amendments in the group, but that's my reasons behind Amendment 95. Thank you, Convener.
And can you move Amendment 95?
Moved, sorry.
Thank you very much. I call Martin Whitfield to speak to Amendment 136 and other amendments in the group. Mr Whitfield.
I'm very grateful, Convener. The amendments that I've brought in this section relate to unusual instances and instances where identification and age of young people can be put as a challenge. And I lodged the amendments in relation to the corporate parenting duties and guidance section, because it is something that, again, if we look to the purpose behind the promise, which is to give our cared for young people the best opportunity to be loved and, as they progress through life, to be set into a future, sit as part of an obligation that I would seek to place on corporate parenting to frankly do the best for these young people, to ensure that they have all of the legal paperwork, to ensure that they have the best emotional support and empathetic support to go on. And so the purposes behind the amendments in this section of 136, 140 and 141 relate to specific areas where questions can arise, and to seek to place an obligation on the corporate parent to ensure that the best is done for the young people who come before them.
Thank you. I call Ross Greer to speak to Amendment 137 and other amendments in the group. Mr Greer.
Thank you. So Section 63 of the 2014 Children and Young People Act requires corporate parents to have regard to any guidance that's issued by ministers, but ministers aren't actually required to publish such guidance. They may do so, and thus far ministers always have. But I do think that that should also be a requirement. If corporate parents are required to follow the guidance, then there should be a requirement that the guidance always has to exist. So Amendment 137 would require ministers to issue guidance in relation to corporate parenting, and in subsection 2 it changes may to must for advice and information, which currently may be included in that. So this isn't intended to be an exhaustive list, but it creates a starting point, a baseline for the areas that the guidance has to cover. In order to keep the promise by 2030, ministers really should be producing guidance that includes regular renewal of corporate parenting training. The committee recommended in our Stage 1 report that consideration really needs to be given to mandatory training for all corporate parents, and there should be a requirement to update the training on a regular basis. So to be effective, I think the guidance should also be accompanied by training. So as alongside 137, which is may to must, Amendment 138 therefore requires that training, including the renewal of training in relation to corporate parenting responsibilities, is included in the guidance published by ministers. So this is not a dramatic change to the current system. It's simply ensuring that the guidance that must be followed, if it exists, always exists, and that guidance includes training content as well. Yes.
Martin Whitfield.
I'm grateful for Oscar for taking the intervention. And in his mind, in this guidance, do you think the areas that have been covered in the amendments that I've proposed actually could be placed? So in essence, to ensure that our cared for community, as they launch off in that guidance, the expectation that the best is done for them could appear.
Ross Greer.
I think that probably would be quite helpful, and therefore I think it's advantageous to be reconciling these two issues at Stage 2. If Mr Whitfield's amendments and mine both pass, then perhaps there'll be a little bit of tweaking required at Stage 3, but the principle of it absolutely, and I'll certainly be supporting his 136. Thank you.
Thank you. I call Paul O'Kane to speak to Amendment 166 and other amendments in the group. Mr O'Kane.
Thank you very much. Convener, my Amendment 166 and its consequential amendment at 219 in this group would require the Scottish Ministers to bring regulations regarding data collection and reporting for corporate parents. That would, I believe, create a more streamlined and effective data collection and reporting requirement for corporate parents to ensure that there is accurate information that is publicly available about care-experienced people. The data collection requirements should include longitudinal data on the outcomes of care-experienced people throughout their lives, including their ability to access housing, employment, education and training, qualities data on children taken into care and the families which they are removed from. This could include protected characteristics and care experience to identify patterns and address any systematic bias, and of course opportunities to better target early intervention and family support. And for local authorities, data on the extent to which advocacy services are being utilised, as well as how care-experienced young people are engaging more broadly with advocacy. For example, whether they use a phone line, or whether they access information online, or whether they have a face-to-face meeting with an advocate. I think any other data also deemed relevant based on consultation with care-experienced children, adults and stakeholder groups, and indeed the corporate parents within the state more widely. This amendment really does seek to ensure that we make progress towards keeping the promise by having the most accurate data and understanding exactly what the picture is across Scotland. I think it would ensure greater accountability, but also go some way into setting out actionable parameters for what keeping the promise actually means. Thank you, Convener.
Thank you. I call Willie Rennie to speak to Amendment 169 and other amendments in the group. Mr Rennie.
Convener, I do, like you, appreciate the new approach of the Government to accepting amendments subject to change at stage 3, and I fully expect all my amendments for the rest of the morning to be accepted by the Minister on that basis, and I am prepared to work with her at stage 3 to improve them even further. My amendment, I've been working with Who Cares Scotland, and it's regarding the streamlined data collection, reporting and planning duties for corporate parents on existing corporate parenting responsibilities, provisions of the bill and other outcomes of the promise to be produced in agreement with the Scottish Government and COSLA. This includes data on how care-experienced people's relationships with their siblings support existing data collection, internal decision-making and provides for that. This is intended to provide a greater and clearer record of decisions made about sibling relationships. The data collection would also include the provision of independent advocacy for care-experienced people. In the Who Cares Scotland report, Is Scotland Keeping the Promise?, it was identified that there are several areas where better data collection is needed in relation to keeping the promise. The area outlined above are important because it ensures that there is a more proactive approach in data collection for corporate parents and upkeeps accountability for future and previous legislation. Yes.
John Mason.
I thank the member for giving way. I mean, I almost intervened in Mr Kane on the same point, but how onerous does he think this would be for the corporate parents? Because what we don't want is some huge bureaucracy, building up around this.
Willie Rennie.
It's actually insufficient as we currently stand. We do not understand fully about the outcomes for care-experienced people. So we have to go some to create an unnecessary burden in this area. So I think this is a reasonable approach to it because there is such a vacuum of data. And we'll need that data in order to make better decisions about the public services that we provide for these people. So ultimately, it will be about improving public services for the longer term. So it will lead to greater efficiency and effectiveness. And I'll conclude on that point.
Thank you. Minister.
Thanks, Convener. Convener, Section 3 of the bill expands corporate parenting duties and responsibilities to all current and formerly looked after children and young people from birth to age 26, which means that corporate parents can support the needs and ambitions of all children and young people who have been looked after within the framework of care, continuing care and aftercare. Now, Ros McCall's Amendment 95 would remove that age range, giving local authorities discretion to determine that an individual no longer needs support before the age of 26. It would mean that local authorities could no longer be required to carry out corporate parenting responsibilities towards children and young people leaving care. I think that goes against the grain of what we're trying to achieve here, and I hope Ros McCall will not press her amendment. If she does, I would encourage members to vote against. Martin Whitfield's Amendment 136 requires local authorities, where they are uncertain about a young person's age and have reason to believe that the person is under the age of 26 years, to assume that is the case. Now, I understand the intent behind the amendment in relation to unaccompanied asylum-seeking children, and I hope I can assure members that it's unnecessary. There's already detailed age assessment guidance which has as its purpose determining whether the unaccompanied child should be accommodated by the local authority as a looked after child or placed in adult dispersal accommodation. The age assessment generally materialises for children and young people around the age of 18 rather than 26, when age status would very likely be settled and young people would be afforded advice, guidance and support from local authorities. So I hope that reassures Martin Whitfield and he will not need to move... Yes.
Martin Whitfield.
I'm very grateful for the Minister to take an intervention. Isn't it the case that the local authorities are being expected to accept an age assessment made by others rather than undertake the responsibility themselves at the minute under the present regulations and legislation?
Minister.
I mean, there is specific guidance in place for age assessments. So what Martin Whitfield brings to me in terms of being expected to take the age assessment from somewhere else, or sorry, if Mr Whitfield wants to make an intervention again, I'd really like to understand the point.
Take an intervention. My understanding is that at present the age assessment is made prior to the local authority's involvement, is made under guidance that relates to other areas of legislation and regulation, and the local authority are in essence invited to accept that irrespective of evidence that's placed before them. One of the purposes behind this and the other amendments is to remind the responsibility on corporate parenting actually to undertake the assessments themselves, and the appropriate may well be that they accept it, and I can see all of that, but not to take as a blanket fact something that's presented to them when they have contrary evidence that may be presented by the young person themselves.
I would just clarify to Mr Whitfield that local authorities do have to do their own assessment, so it wouldn't be granted on the opinion of someone else or another form of assessment. So I would hope that that reassures Martin Whitfield and he would not need to move his amendment. If he does, I would encourage members to vote against Amendment 136. I thank Mr Greer for bringing Amendments 137 and 138 forward. I welcome any proposal which will help strengthen corporate parents' understanding of how they can support their rights and well-being of children and young people with experience of care. I fully support these amendments, which will ensure all corporate parents in Scotland are provided with advice and guidance from ministers on how to fulfil their duties, and I hope that members will too. The UNCRC and Corporation Scotland Act 2024 already makes it unlawful for a public authority to act or to fail to act in a way that is incompatible with the UNCRC requirements when exercising functions conferred by Acts of the Scottish Parliament, Scottish statutory instruments made under Acts of the Scottish Parliament powers or common law powers. This duty also applies to functions of a public nature carried out under a contract or other arrangement with a public authority. Now, the corporate parenting duties responsibilities under Part 9 of the Children and Young People Scotland Act 2014 are within scope of the compatibility duty in the UNCRC Act. So Mr Whitfield's Amendment 140 is unnecessary. I hope he will agree and not move it. Mr Whitfield's Amendment 141 would require certain further matters to be included in corporate parenting guidance and for ministers to ensure that there is adequate training on those matters. The Scottish Government is committed to supporting corporate parents and to publishing statutory guidance on corporate parenting responsibilities, as well as on aftercare and the definition of care experience to support the bill's implementation, and we would expect relevant corporate parents to follow this guidance. And while staff training is a matter for corporate parents to undertake in order to ensure they can fulfil those functions, the Government funds training and networking opportunities for all corporate parents in Scotland. Now, I think Ross Greer's Amendments 137 and 138 cover similar matters to Amendment 141. I would hope Martin Whitfield might not move his own amendment and support those. I understand the intention behind Paul O'Kane's amendments 166 and 221 and Willie Rennie's amendments 169 and 224. Reporting on progress of delivering the promise is important, and I want to assure both members that work is underway in that regard through non-statutory mechanisms. The Promise Story of Progress, which was updated in December 2025, it was developed jointly with COSLA and the Promise Scotland, already provides a strong example of the partnership working underway to shape our approach to understanding change. A really key aspect of this, I think, is the Promise Progress Framework, which sets out across 10 vision statements with key national metrics against which progress can be measured, including in areas such as educational engagement and attainment and restrictive practices. Now, many of these metrics are drawn from data that's published by partner organisations which support their interpretation, and I think that provides a really strong basis for understanding progress and directing further action. However, I acknowledge that transformational change is required and that progress must be understood not only through outcomes but also through the lived experiences and activities that shape those. So 2 additional strands of the story of progress seek to do this by focusing on organisational activity and the experiential impact on the care community. And this work is supported by the Promise Data and Evidence Group. Now, this group was established to help identify and address data and evidence gaps which exist around the promise, something that I believe both the members spoke to. A key principle of this work is to, wherever possible, identify solutions which utilise existing data and novel data linkages to address gaps, minimising additional burdens for those working at service level. I'm very, very grateful to Linda Bald, Scotland's National Social Policy Advisor, who is steering this work, and to the member organisations for their productive collaboration, including Public Health Scotland and the Improvement Service. I've been clear, I definitely don't want to duplicate work or, as Mr Mason points out, add unnecessary bureaucracy. Sometimes government can manage to set and train actions which deliver in practice what is being sought in statute, and I really do hope Paul O'Kane and Willie Rennie might consider this to be one of those moments. We've already established the mechanisms to gather data and evidence, to map progress, to map culture change and capture experiences and make it all publicly available so that everyone can see if we and all the delivery partners are keeping the promise. So I hope they might agree with me and not move their respective amendments. Thank you.
Thank you. I call Ros McCall to wind up and press her withdraw Amendment 95. Ms McCall.
Thank you, Convener. I listened carefully to what the Minister had to say there. First of all, on my amendment, I don't believe that that's what my amendment does. GIRFEC has been at the heart of everything that has gone out on children's services for over 20 years. That is meant to have getting it right for every child and have the child at the centre of every process. So if the Minister is actually stating that we are in a situation with this amendment where it would allow councils to opt out, then every policy that has been put forward isn't working. So I don't believe that that is what my amendment does. I have a theme in a lot of my amendments. I am looking at the age range of where care applies. And I believe that if we keep continuing to put limits on that, then we will always have that cliff edge, and it is that I am trying to change. With regard to the rest of the amendments in the group, I don't have anything more to add, Convener, and I will be pressing amendment number 95.
Thank you very much. The question is that Amendment 95 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 95? Thank you. And those against? Thank you. The result of the vote on Amendment 95 is yes 5, no 5. As the outcome of the division is tied on Amendment 95, I will now use my casting vote as convener. In order for the committee to reach a decision, I vote in favour of Amendment 95. Therefore, the committee agrees to Amendment 95. I call Amendment 136 in the name of Martin Whitfield, already debated with Amendment 95. Martin Whitfield to move or not move?
Move.
The question is that Amendment 136 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 136? Thank you. And those against? Thank you. The result of the vote on Amendment 136 is yes 5, no 5. As the outcome of the division is tied on Amendment 136, I will now use my casting vote as convener. In order for the committee to reach a decision, I vote in favour of Amendment 136, so the committee therefore agrees to Amendment 136. I call Amendment 137 in the name of Ross Greer, already debated with Amendment 95. Ross Greer to move or not move?
Move.
The question is that Amendment 137 be agreed to. Are we all agreed? Yes. That is agreed. I call Amendment 138 in the name of Ross Greer, already debated with Amendment 95. Ross Greer to move or not move?
Move.
The question is that Amendment 138 be agreed to. Are we all agreed? Yes. We are agreed. The question is that Section 3 be agreed to. Are we all agreed? Yes. That is agreed. I call Amendment 139 in the name of Paul O'Kane, group with Amendment 142. Paul O'Kane to move Amendment 139 and speak to both amendments in the group. Mr O'Kane.
Thank you very much, Convener. My amendment in this group would place duties on corporate parents to provide pathways and support for care leavers to find employment and training. Sorry, Convener. This includes both the provision of careers guidance and support by dedicated officers, as well as the provision of dedicated work experience, opportunities and traineeship for care leavers. In addition, the Scottish Ministers must, as soon as reasonably practicable, introduce guidance for local authorities on supporting care experienced young people into work. This guidance should include provision on the role of employment officers and how local authorities should implement employment pathways, such as work experience opportunities and apprenticeships for care leavers. The effect of the amendment is to require corporate parents to have dedicated employment officers who are responsible for supporting care experienced individuals into work. That follows examples of good practice from local authorities in Wales. In 2017, the Children's Commissioner for Wales produced the Hidden Ambitions report, which involved commitments from the Welsh Government to act like a large family business by providing pathways into employment for care experienced young people who are not in education, employment or training. As I think we acknowledge, one of the roles that most parents will play for their children is to help them through the transitions to adulthood, and as part of that is entering the workplace and moving beyond the world of formal education. I think that this is relevant too in terms of the duties we place on corporate parents. I think if we want to do right by Scotland's cared for and care experienced young people, then we need to ensure that people and entities are charged with acting out their corporate parenting responsibilities in all its functions, not just to care for them in the moment, but actually to show care by providing future and positive pathways and ongoing support. Thank you.
Thank you. Sorry, can you move your amendment?
Moved.
Thank you. I call Willie Rennie to speak to Amendment 142 and other amendments in the group. Mr Rennie.
So, my Amendment 142, I've been working with Duncan Dunlop, who I referred to earlier. This builds on the proven success of national education support schemes by extending the same ambition and accountability to employment, ensuring care experienced people can achieve economic independence and stability. The Scottish Ministers must, in exercising their functions, ensure that every person who is care experienced is guaranteed access to supported employment opportunities, whether part-time or full-time, up to the age of 30. Ministers must work with public bodies, local authorities and employers to establish a national employment scheme for care experienced people, modelled on the successful bursary and support programmes for further and higher education, ensure flexible routes combining employment and education, and finally, publish an annual progress report. Yes, certainly.
Miles Briggs.
I appreciate the member taking intervention. The committee's just considered the Further and Higher Education Bill, and very sympathetic to his amendment. In terms of guarantee, what does he envisage that then providing in terms of if there's not a guarantee of an apprenticeship opportunity or a guarantee of actually further education being provided? And I'm just a wee bit concerned over that word guarantee and what that would look like in reality to not deliver something.
Willie Rennie.
The guarantee is to access to supported employment opportunities. It's making sure that the range, in a similar way that we've got for further and higher education, is provided on an employment basis. Now, it's up to individuals whether they wish to take that employment, but it's that guarantee that there will be an availability to make sure that they can advance. But the final issue will be about the publishing of the progress report on the number of care experienced people supported into employment, training or apprenticeships. That's my question.
Thank you. Minister.
I absolutely recognise the intention of Amendment 139 in the name of Mr O'Kane, but I do believe the amendment duplicates support that already exists. In Scotland, the No One Left Behind approach has established an employability system delivered through local employability partnerships. Scottish Government provides funding to these partnerships so that key workers are in place to provide employability support that's tailored to the circumstances and the needs of its participants. This includes care experienced people who are set out as a priority group for this funding. Since April 2019, almost 7,000 care experienced people have accessed No One Left Behind support. This amendment would place an unfunded additional requirement on corporate parents without sufficient clarity on the additional benefit it's intended to create. Many corporate parents already engage with devolved employability services through local employability partnerships, as employers and anchor institutions and as referring organisations. Creating a separate statutory responsibility risks upsetting that good practice that's already happening and funded, and worse, creating duplication of provision. Again, I appreciate the intent behind Willie Rennie's amendment Of course, we all want young people who have been in care to thrive in adulthood and to have good employment opportunities to open to them. However, this amendment in part appears to extend beyond the employability powers available to the Scottish Parliament. Over and above the issues of legislative competence, this amendment would again risk placing unfunded duties on the person specified within the provision, without consideration as to how this should be resourced, while also duplicating aspects of existing devolved employability provision already in place, as I've just set out. Again, the amendment ignores the funded provision already available to care-experienced young people as a priority group. And I think we just need to be a little cautious around assuming then, when this has already came up, that employment would always be the best or first option or priority for care-experienced young people. As we've heard, it might be that an apprenticeship or further or higher education is a better fit for the aspirations of the young person before moving into employment. So where we undoubtedly, I think, share a common objective is to ensure that every young person leaving care has those opportunities to fulfil their potential and gets the appropriate targeted advice and support that's best for them and to help them to do so. So the 2015 aftercare regulations, of course, already expect care leavers to be given advice, guidance, assistance on education and employment opportunities. However, given the intent, I'm happy to discuss with Paul O'Kane and Willie Rennie what more we might do in this area, whether that is in a legislative fashion or a non-legislative fashion, in terms of building upon that work that's already there. So I would ask members not to press their respective amendments. Should they do so, I would encourage members to vote against amendments 139 and 142.
Thank you. I call Paul O'Kane to wind up and press or withdraw Amendment 139. Mr O'Kane.
Thank you very much, Convener. And I realise that I think there is a shared ambition on this agenda, and I recognise what the Minister said about existing services that are in place. However, I would suggest that putting this on a statutory footing actually allows a far more dedicated focus in terms of the specific requirements for care-experienced young people in particular. I pointed in my opening remarks to the good practice that exists in Wales and what has been done there in terms of taking that very dedicated corporate parenting approach, again, that family business. That does happen in certain authorities in Scotland, I think, in terms of family firm and things like that in East Renfrewshire, which obviously I know particularly well. I think we could, however, do more, and I do think that is why a provision within this bill is the right place to actually set this, as I say, in a statutory footing and to formalise some of the supports that the Minister, I think, makes reference to. I appreciate that she wishes to have further discussion and debate, and that seems to be the tenor of this morning. I am, of course, willing to do that, but given the importance of this issue, I think I will press at this point. Thank you.
Thank you very much. The question is that Amendment 139 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 139? Thank you. And those against? Thank you. The result of the vote on Amendment 139 is yes 4, no 6. Amendment 139 is therefore not agreed to. I call Amendment 140 in the name of Martin Whitfield, already debated with Amendment 95. Martin Whitfield, to move or not to move? Move. The question is that Amendment 140 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 140? Thank you. And those against? Thank you. The result of the vote on Amendment 140 is yes 5, no 5. As the outcome of the division is tied on Amendment 140, I will now use my casting vote as convener in order for the committee to reach a decision. I vote in favour of Amendment 140. Therefore, the committee agrees to Amendment 140. I call Amendment 141 in the name of Martin Whitfield, already debated with Amendment 95. Martin Whitfield, to move or not move? Not move. I call Amendment 142 in the name of Willie Rennie, already debated with Amendment 139. Willie Rennie, to move or not move? Not move. Thank you. I call Amendment 143 in the name of Ross Greer, group with amendments as shown in the groupings. Ross Greer, to move Amendment 143 and speak to all amendments in the group. Mr Greer.
Thank you, Convener. Apologies, scrolling back to it. There we are. I just want to start off this group by just briefly quoting the section of the promise that I think is relevant to it, where it says, all of Scotland's institutions, organisations, national bodies and local authorities who have responsibility towards care-experienced children and young adults must be aware of, understand and fully implement all their parenting responsibilities. What care-experienced children and young adults need must be at the heart of decision-making so that all of Scotland can live up to its parenting responsibilities. End quote. Section 5 requires ministers to issue guidance for the purposes of promoting an understanding by public authorities of care-experienced persons, which I obviously support, but I don't think that goes far enough. Being care experienced obviously isn't a protected characteristic under the Equality Act, so there's no obligation on public bodies to consider the impact of their decisions on care experienced people in the way that they're required to for other characteristics through the public sector equality duty. I don't think guidance alone solves that issue, and while making care experience a protected characteristic is a live debate, it is a live question, it's obviously out with devolved competencies. What we can do, however, is put general duties on public bodies to have regard to and consider the impact they have on care experienced people when they go about discharging their duties in a matter that would affect them. So Amendment 143 would put that requirement in law. It would ensure a more systematic approach to considering the needs of the community. It doesn't predetermine decisions. It doesn't predetermine the outcome of any decision-making about how they discharge their duties. But what it would do is it would force public bodies to at least consider what impact they'll have on care-experienced people first. So this is a broad, but I think quite simple, not particularly restrictive duty on public bodies. It will simply force them to ask themselves that question before going about discharging their duties. Thank you.
And can you move Amendment 143?
Move Amendment 143.
Thank you. I call Paul O'Kane to speak to Amendment 157 and other amendments in the group. Mr O'Kane.
Thank you very much, Convener. These amendments would strengthen the duty placed on public authorities by ensuring that they must have due regard to guidance and their duties. These amendments were called for by many stakeholders, including the Promise Scotland, in recognition of the well-established and understood meaning of due regard in law. Amendment 157 would have the effect of ensuring that care-experienced people can self-identify as care experienced rather than being subject to a top-down definition of care experience, and ensuring that they can access the support they are entitled to and they need. The effect of the amendment is self-explanatory, but I do want to acknowledge the work that's ongoing to progress a universal definition of care experience. However, I think without a clear timeline for that work, or the expansiveness and inclusiveness of the final definition, I do think it's important that we talk of an inclusive approach to that definition to ensure that support gets to where it needs to go as quickly as possible. So I am open to hearing the Minister's update on those efforts, which I'm sure she will speak to shortly. I also would acknowledge the concerns that self-identification in an open process may be abused, and people may wrongly identify themselves as care experienced. I acknowledge that has a risk and there are unintended consequences. However, I do think that they are far lower than perhaps the risks of not having a definition as quickly as possible to allow people to definitely access the support that they require. So this amendment, I think, probes these issues to some extent, and I'm willing to engage in the debate, and I will leave it there for now. Thank you.
Thank you. I call Rose McCall to speak to Amendment 100 and other amendments in the group. Ms McCall.
Thank you, Convener. Again, I'll start by speaking to my amendments. Amendment 100. Trauma-informed practice should not depend on postcode or leadership culture. This amendment embeds in statutory guidance, making it an expectation rather than an aspiration. In the real world, this shapes how children and families experience services, whether they feel heard, respected and safe. And that's what this Amendment 100 is trying to do. Amendment 99 is protecting infants through informed decision making. Decisions about family time for infants have lifelong consequences. This amendment ensures guidance reflects evidence on attachment, trauma and development. It does not remove professional judgment, it strengthens it. And without this, we risk inconsistencies and decisions that prioritise process over the child's development needs. Amendment 159. This amendment assures that there is support and advocacy entitlements that follow the person, not the postcode. Its purpose is to prevent loss of support when care experienced people move between local authority areas. And Amendment 101, there is a world of difference between having regard to and giving due regard to. This amendment strengthens the legal weight of guidance, so it must be meaningfully informed decisions. Without it, guidance risks being acknowledged and ignored. And could add some comments just to sort of on regards to 157, the amendment in the name of Paul O'Kane. I'm having difficulty with this particular amendment, as we don't have a comprehensive definition of care experience. It's impossible to self-identify. So I think we need the process. I think needs to be a better assessment process, better support when support is needed. But to muddy the water by including self-ID, I think will actually make the situation worse, maybe not better. But I am supportive of the other amendments in the group. But I would like to hear more from Mr O'Kane on that particular amendment, if possible. And I will certainly listen to the information from the Minister, because I am concerned that that will actually make the situation worse, not better. Thank you, Convener.
Thank you. I call Miles Briggs to speak to Amendment 158 and other amendments in the group. Mr Briggs.
Thank you, Convener. And the reason behind this amendment I brought forward, again relating back to the evidence we took from the Social Justice and Social Security Committee, because a story which has stayed with me was a grandparent who told us about their experience, which was very much around the police coming to their home in the middle of the night with their granddaughter, half naked, to hand her over. Now, the family obviously stepped up. But in private, there was a lot of conversation over concern which kinship carers, most often grandparents, have around social work and the potential for children to be taken off them. And that's where often they don't look towards reaching out for help, and we see a crisis situation build. So the intention behind this amendment is, I hope, to promote and normalise the offer of whole family support to kinship carers across Scotland. The Care Review said that it heard from many kinship care families about the lack of support they are having for caring for children. They fear that sometimes they fear sometimes of having to ask for help. Principles, it said clearly, the principle for intensive family support that wrap around a family must be accessible to kinship families, as to families of all origin, and support must be offered freely without kinship carers having to fight for it, and kinship carers should not feel the need to professionalise their role in order to access support. Kinship carers continue to tell us that they struggle to find and access offers of whole family support, and the Scottish Government have said that kinship carers in informal or formal arrangements will be included in the scope of this guidance. That means it's an important opportunity to be clear about the support that should be available to kinship carers and children and what that should look like. If the promise is to succeed, more children will be supported to live with their families. However, if kinship is relied on more and more without any investment in the supports those children and families need to thrive, they'll feel as though they are being set up to fail. And so promoting good practice around whole family support offers to children in kinship care arrangements as part of the work the Scottish Government planned to do on the guidance, I would think would help move that forward. So I'm pleased to move 158 in my name.
Thank you. I call on Martin Whitfield to speak to Amendment 165 and other amendments in the group. Mr Whitfield.
I'm very grateful, Convener. My Amendment 165 deals with the question of restraint and seclusion. The Chamber has already discussed restraint and seclusion in relation to the Schools Bill, and the amendment that I propose is in respect of guidance being provided for restraint and seclusion in care settings. It is very important that all of those involved in the system, both our young people but also the adults that surround them and those that support them, are given proper and full guidance on expectation and on collection of data and on understanding. If I go back to the some of the speeches that were put forward in the Schools Bill, the concept of a child coming home from school where they have injuries that have no explanation because of seclusion, of course leads to automatic questions from those parents as to what happened. In the setting that we're talking about, there is no physical parent to go home to. It is a corporate parent, and therefore all the more so guidance needs to be provided. I wait to hear from the Minister, and I do, in hopeful anticipation, that we are pushing, if not on the wording of this amendment, on an open door with regard to guidance. So I'll leave it at that point.
Thank you. I call on Sue Webber to speak to Amendment 102 and other amendments in the group. Ms Webber.
Thank you, Convener. The Stage 1 scrutiny highlighted some concerns around inconsistency when it comes to access, funding pressures and the need for that clear expectation around availability for services. What my Amendment 102 would do would place a duty on local authorities to ensure that any eligible child, which is defined as one who is or is at risk of becoming looked after or is otherwise specified in regulations in their area, is able to access such services if it would be appropriate for them to do so, because right now prevention isn't a statutory duty, and as a result local authority children's social work spending is increasingly skewed towards care services, with a significant proportion of resources being absorbed by servicing the demands of the care system itself. A social worker may recommend that a child can be taken into care, but has no authority over budgets for alternative services that might keep a child safely within their family, home or the wider kinship network. Taking a child into care can entail costs of hundreds of thousands of pounds, while preventative support is often treated as an unaffordable expense. And this dynamic transfers scarce resource out of poorer families and communities and increasingly into private provision. The reality means that if there is a condition of a CPO or compulsory supervision order for a child to go into care, then resources are made available. For complex residential placements, this can be hundreds of thousands of pounds paid to mostly these private. Not at this time, Mr Mason. As I'm concluding, a social worker cannot access the necessary services and resources that might be available to prevent that child from going into care, and it's not addressed in this bill. And my Amendment 124 turns this into an affirmative regulation procedure. And both together, these amendments move the bill towards obligation, capability and the equity of access across Scotland. Thank you, Convener.
Thank you. Minister.
Thank you, Convener. Ross Greer's Amendment 143 would, through regulations, require public bodies in the exercise of their duties to have regard to the needs of care-experienced persons. The bill, as introduced, already contains provisions that would more appropriately take forward defining how and which public authorities would have regard to the needs of care-experienced persons through the development of guidance. Section 5 places a duty on public authorities to have regard to that guidance when exercising their functions in relation to care-experienced persons. I would hope that this reassures Ross Greer and he will not press his Amendment 143. If he does, I encourage members to vote against it. I do believe further amendments I intend to support in this group will appropriately meet the intention of this amendment. However, I am happy to discuss any further concerns that the member may have. Paul O'Kane's Amendment 157 would include those who self-identify as care experience within the ambit of the guidance under Section 5(1) of the bill. While I recognise that Section 5 does not explicitly include people who may self-identify as care experienced, Section 5(6) does enable the guidance to specify other circumstances in which someone cared for or supported could be considered as care experienced, and this would enable provision to be made in that regard. The guidance will provide clarity on how this works in practice, ensuring actions are proportionate and respectful, but I am happy to look again at Section 5(6) to see if further clarification could be provided on this. Mr O'Kane asked for an update on the definition of care experience. Now, he will be aware there was a consultation on this, a long period of engagement. I am more than happy to write to the committee if they would like an update around the progress so far. I welcome Ros McCall's Amendment 100 and I am happy to support it, although minor adjustment may be required at Stage 3. This amendment would make it explicit that rights-based trauma-informed best practice may be promoted in the statutory guidance for care experience. The guidance will shape day-to-day practice and ensure a shared, consistent understanding of care experience across services and set a national and consistent direction for the language used in and around the care system. Embedding rights-based, trauma-informed practice is essential to reducing stigma and improving outcomes for care experienced people. Amendment 158, I agree with Miles Briggs on the importance of ensuring that kinship families receive the guidance and support they need, but I cannot support Amendment 158. And my concern is not the principle of the whole family support for kinship families by any means, but it's that the guidance that will be published under Section 5 of the bill, I don't think is the right place for this. There's already more appropriate guidance in place and being developed, some of which I've spoken to already this morning, to address kinship care more directly. And I do want to avoid the potential for confusion and conflation of these two important issues. I believe that guidance which is focused on care experience and kinship families is given the standalone prominence and direction that it rightly deserves. So for those reasons, I would ask Miles Briggs not to press the amendment. Ros McCall's Amendment 99 highlights the importance of sensitive decision-making for infants and their families. I want to assure Ros McCall that we are working to address that. National material on infant contact already exists, including the CHS Infant Guidance, which is aimed specifically at panel members, and forthcoming AFCA Permanence Guide, due for publication in April, which will provide advice for practitioners. My concern about this amendment is that introducing infant contact into Section 5 could change the focus of this guidance and create uncertainty about its intended role. On that basis, I cannot support it. Amendment 159, I recognise the intention behind this amendment to ensure consistency when care experienced people move between local authorities. However, it does fail to account for variations in local capacity and service delivery models within local authority areas, and it doesn't consider the nuances and differences in service provision between local authority areas. This is the potential of creating a national approach. For this reason, I would ask Ros McCall not to press the amendment, and if she does, that members vote against it. But there are three amendments, I think, with broadly the same intent. Ros McCall's Amendment 101 and Paul O'Kane's Amendments 160 and 161. All three seek to change the duty on public authorities to have regard to care experience guidance published as required by Section 5 of the bill to either give due regard, Amendment 101, or have due regard, Amendment 160 and 161. I support the intention of these amendments as they respond to the views raised by stakeholders during Stage 1 that the duty should be to have due regard to the guidance. While both members' proposed amendments aim to bring the same effect, Paul O'Kane's Amendments 160 and 161 provide more consistency within Section 5. So if Ros McCall is content to accept that approach, I would consider her not to move her amendment. Martin Whitfield's Amendment 165 allows us to debate a very important issue, and I thank him for bringing it to us. The Scottish Government supports the Promise's ambition that Scotland will be a nation that does not restrain its children unless in exceptional circumstances. For that reason, we are currently funding the Holding Differently project, which aims to strengthen our evidence base about practices which work in reducing restraint, and therefore to allow for better training and support for staff in care settings. Now, we had originally seen merit in waiting to see the results from that project before legislating on restraint in care settings. However, we recognise that the Parliament is currently considering legislation on restraint in relevant education settings. This legislation is likely to create a statutory basis for guidance on restraint in those settings. And we also know the view expressed by Mr Whitfield, the Promise Scotland, the Children and Young Persons Commissioner for Scotland and others, that we should take the opportunity through this bill to legislate on restraint in care settings. I want to do that. However, there are two reasons why I am not able to support Mr Whitfield's amendment. Firstly, the scope of the amendment needs to be considered carefully. As drafted, the amendment would cover home-based settings such as foster care and kinship care. We know that home-based care is fundamentally different from institutional care, and applying statutory guidance to family homes as well as to institutional settings, I think, risks blurring that distinction. And I'm also not convinced on the government guidance on restraint in home-based settings would be either practicable or workable. Secondly, yes, I will.
Yes. Martin Whitfield.
If the minister is, if the minister is able to confirm that this is the bill in which an amendment relating to guidance on restraint and seclusion in care settings should appear, I can confirm I won't push this amendment.
Minister.
I am going to make that assurance. I just have some further points, but absolutely, yes. So secondly, the proposed amendment as currently framed doesn't address some of the issues such as what the guidance will cover, who it will be addressed to and what the duty should be under to apply it. I think it would be helpful to cover those and others in primary legislation, along with provisions on other matters. But I do want to acknowledge that by the end of this parliamentary term, we may well have separate legislative provisions for statutory guidance on restraint in both educational and children's residential care settings, and a risk of that same guidance applying to the same setting which provides education and residential care. So how we implement those provisions will need to be very carefully considered. And I think it will be important for the next Parliament to ensure that provision in these settings and in mental health is aligned. So, while I cannot accept Mr Whitfield's amendment at stage 2, I do commit that the Scottish Government will work on an amendment at stage 3 which will provide for statutory guidance on the use of restraint in care settings. This amendment will, at the very least, cover children's residential care settings and secure care settings. And on that basis, as I understand Mr Whitfield, I would ask him not to move his amendment, and I understand that he's not going to. In relation to amendments 102 and 124, I absolutely share Sue Webber's ambition that we must keep families together in Scotland where it is safe to do so and ensure that they are well supported. I do value and understand the importance of ensuring that any decision is made is in relation to family separation is carefully considered and based on robust assessment. There are currently statutory duties on local authorities to assess looked after children and provide a plan on those long and short term needs, and there are also duties on local authorities to provide services to children in need who may be at risk of becoming looked after that promote the upbringing of such children by their families. Now, supporting families to stay together is important, but for some children, continuing or resuming residence with a parent would not be safe, would not be in their best interests, and the law must preserve professional judgment to act where separation is necessary. The best interests of the child are absolutely paramount and should be the paramount consideration of local authorities in their assessments of a child's need. I am committed to continuing to improve care experiences for children across Scotland and to promote awareness of the services that are presently available. I would ask that members resist this amendment on the basis that this provision would not enhance or improve the support children and families receive to remain together. Group 8 covers a wide range of important concerns across the bill, and I thank members for bringing forward their amendments and enabling us to debate them. In conclusion, for the reasons I've set out, I would ask Ross Greer not to press Amendment 143, Paul O'Kane not to move Amendment 157, Miles Briggs not to move 158, Rose McCall not to move 99 and 159, Martin Whitfield not to move Amendment 165 and Sue Webber not to move Amendments 102 and 124 for the reasons that I have set out. I would also ask members to support Amendment 100, 160 and 161.
Thank you. I call on Ross Greer to wind up and press or withdraw Amendment 143.
Thank you, Convener. I'm still inclined to think that a simple, broad provision for public bodies to have due regard is the ideal option here, but I take on board what the Minister said. I'm glad that she's accepted a couple of the other amendments in this group, particularly in relation to the language around due regard. On that basis and her offer to continue discussions ahead of stage 3, I'm content not to press 143 at this point on the basis that I'll support the amendments she's indicated she's supporting later in the group. I do think further discussion ahead of stage 3 will be required, though, because having regard to specific guidance, I think, is unlikely to be sufficient, as opposed to a broad duty to have regard to the needs of care experienced people and the impact decisions are made on them. For now, though, I won't press 143.
Thank you. Ross Greer seeks to withdraw Amendment 143. Does any member object? No member objects, so Amendment 143 is withdrawn. I call Amendment 144 in the name of Jackie Dunbar, grouped with Amendments 146, 147, 8, 151 and 97. I call on Jackie Dunbar to move Amendment 144 and speak to all amendments in the group. Ms Dunbar.
Thank you, Convener, and I move 144 and 151 in my name. I've carefully reflected on the evidence we heard during the stage 1 on this issue and the concerns of stakeholders regarding the lack of clarity on the definition of independent advocacy in the bill as introduced, and I believe that amendments 144 and 151, which I bring forward today, will address those concerns. If adopted, the amendments would place a requirement on the face of the bill that the regulations currently provided for under Section 4.1 must specify that care experience advocacy services should be independent and that those regulations will set out what criteria care experience advocacy services must meet in order for them to be considered to be independent. I have carefully considered the amendments of Ros McCall, Martin Whitfield and Ross Greer, which all seek in varying forms to place a more prescriptive statutory definition of independent on the face of the bill. And I am sympathetic to the intentions behind these amendments and the desire to provide greater clarity on how independent advocacy services will be delivered under this bill. However, I believe that given the intended breadth of the lifelong right to access independent advocacy services under the provision and its application across a whole range of circumstances, the inclusion of a restrictive definition might significantly impact on the range of persons who might have the capacity and competence to provide these services. I mean, we heard from Who Cares Scotland, the young children in the private session at night. I mean, I know I personally heard that while they didn't want, they wanted the choice to choose who their advocate was. And that might be a teacher, that might be a social worker. As one young person said, that a social worker could read by the expressions on her face if she wanted something or not. And by some of the amendments that's forward, that to me would listen, would mean that would maybe prevent them from having that advocate, because like local authorities have got so many different departments and services, but if you're just lumping the local services as one. Yes.
John Mason.
Thank you, Member, for giving way. I just wonder, would she accept that while a young person should be offered an independent advocate, they might choose not to have that independent advocate? They might choose to have one of the persons she suggests that they already have a good relationship with. But it's still important that they should be offered an independent advocate. Jackie Dunbar.
Well, in my eyes, in that case, if it was a teacher, that would be an independent advocate if we weren't littling it down to just local authority. That it had to be independent out with local authorities. And I think it is the young person's right to have independent advocacy, and they should always be offered it as well moving forward. Yeah.
Ross Greer.
I'm grateful for that. I think there's broad agreement that we want to see some kind of independent advocacy. We do at some point, whether it's in primary legislation or in secondary, which I think is the direction Jackie Dunbar's headed in. At some point, it does need to be defined what is independent. Going back to John Mason's point, whether it's offered or whether it is a requirement, we need to decide what independent is. What I'm trying to get a sense of this morning, particularly before I decide whether to move my amendment, is what the settled view across the committee is. And I'm a bit concerned by what Jackie Dunbar's just said about teachers being a source of independent advocacy, but it could be, because they are employees of the local authority. And I'm trying to understand, because at one end of the spectrum, you've got people who will argue that no one who is even from a third sector organisation contracted by a local authority could be considered as independent. I think that probably goes too far. At the other end, though, there's this argument that there are employees of the local authority, like teachers, who could be regarded as independent. I can't see a definition of independence that a teacher, an employee of the local authority, would meet. So I'm just wondering if Jackie Dunbar could elaborate a bit on what she believes an appropriate definition of independence is. Because whether we put it on the face of the bill or we give ministers the power to bring it forward by a secondary legislation, at some point we need to define it.
Well, a teacher would not be making decisions on the cared for experienced persons' ability care, but they would be there to listen to a care experienced person if needed. I am not saying it should be a teacher. I'm saying that the young person should have the right to choose if they so wish. I was just using the teacher as an example of what we'd heard on the evening. As I said, another person had said the social worker. Whether I believe that is right or wrong, not for me to decide. It's for the young person themselves. It's making it sure that we get it right for every child.
Remember taking intervention.
Miles Briggs.
I feel I'm going down a rabbit hole.
No, I don't think you are, because I think I was privy to the same conversation, and completely appreciate, as anyone would, that a young person will see someone, be it their teacher, their social worker, who they trust. I think Ross Greer's point, though, does suggest where is the conflict of interest for who employs them, and at what point do they decide the advice they are giving that young person is 100% independent based on what they need and not actually workforce pressures, budget pressures as well. And that's why I have a concern over what that potentially looks like when we say anyone can be that, regardless of what the organisation at the end of the day they have their contract with.
Jackie Dunbar.
And you've just said that the local authority would have to have a contract with anybody. So does that mean that nobody can? Because then the local authority would be paying for the services of an independent advocate. So it's, I think you've, well, for me, you've just blown the whole argument out of the water then, because the local authority at the end of the day would be paying for an independent advocate. So that's services that's being paid for. I believe working in a... Yes.
Nicola Sturgeon.
Jackie Dunbar spoke about choice, and I think this is one of the crucial elements. A young person should be able to choose the advocate they feel is best able to advocate for them. But isn't it the point that in all circumstances they should have the option of somebody who is genuinely and truly independent and doesn't have any other caring responsibilities towards them? And I take the point she's making about the local authority paying, but and that is, you know, ultimately a requirement. But the crucial point is that there needs to be at least the option, even if the young person doesn't take it, of somebody who has no other responsibilities that, for example, a teacher would have. Isn't that the key point?
Yeah, and I agree with that. But I also believe that they should have the option to have the person that they trust the most, if that's what they wish as well. And I wouldn't like them to be prevented from having that person of trust just because of basically who pays their wages, if I'm being honest, because we, you know, we've, and I think I'll just leave it there, or we'll go further on. But, yeah, I'll leave it at that just now.
Thank you. I call on Martin Whitfield to speak to Amendment 146 and other amendments in the group. Mr Whitfield.
I'm very grateful, Convener. And I think, again, this section goes to the heart of what the promise should be about for our cared for and care experienced community. In this sense, we are inviting a young person by primary legislation to have the right to an independent advocate. In Jackie Dunbar's submission, she talked about the challenge, but it's the local authority who pay. The reality is, if we look at civil and criminal legal aid, it's paid for by the taxpayer, it's paid for through the government, but the advocates that represent there are independent. Now, this is a different type of advocate that we're talking about, and we are not talking about a friend, we're not talking about a confidant that it may well be a young person may well choose a teacher or a trusted adult to do. In this case, we're talking about the individuals who are there to represent the voice of the care experienced person. And the need for that to be independent, I think, is important on a number of different levels. On the most important level, the young person, the care experienced individual, needs to know that they have someone on their side that is not answering to anybody else. They should have the choice of being able to choose that. Similarly, the advocate as an individual and as an experienced and, I would say, professional person needs the ability to advocate on behalf of the child without any other influences coming into play. To the comments again about the role of the teacher and the employer, there are a significant number of individuals who potentially will have a conflict of interest that will both be incredibly challenging for them to explain to the young person, but also incredibly challenging to take that role of remaining the advocate for the young person and independent. I think it is interesting, and I think it speaks to the challenge that this sits, that it's taken to get to this stage where we are starting to try and identify what independence means. And there are a number of amendments in this group that, quite frankly, are not dissimilar. We could suggest that great minds think alike, or alternatively, we have a very experienced drafting team who can see through politicians' gobbledygook. And so there are a number of options that are available, but there is a key to all of those, and that is that there is an independence and a separation from an agreed group that independents should be independent from. The local authority, the Health Board, the National Health Service Trust, local authority, Health Board, again, National Health Trust and respective members of it, the corporate parent and a lead children's service planning body, although that slightly is extended in mind rather than the others. And that is because I think everyone who's submitted amendments in that vein in this have looked to a group that, to take the old adage, even though the young person or care experienced person may not be able to see it, society should be able to say they are independent of people who are making judgments and taking decisions on behalf of young people. I look forward to hearing from the other submissions and hearing from the Minister. But I feel this question of independence needs to appear in the primary legislation, if I suppose in part in vain of some of the amendments that have been accepted this morning, so that we can look forward to seeing where we can coalesce around it at stage 3. And I'll leave it at that stage.
Thank you. I call on Ross Greer to speak to Amendment 147 and other amendments in the group. Mr Greer.
Thank you. I'll try and avoid just repeating, I think, all of the arguments that we aired, and thank you to Jackie Nambar for allowing many of us to essentially have a debate within her contribution on this. It is worth repeating one point, though, that it's absolutely clear from a lot of the evidence that we've received and a lot of this representation that many of us have had over years, that there is a chronic lack of trust very often between care experienced young people and those whose job it is to support them, but who are employed by the same local authority that the young person themselves is often in conflict with or struggling with in some way. There is a clear conflict of interest, or at least the perception of a conflict of interest, which is equally important when you have someone advocating potentially against their own employer, or at least advocating for a position which is not in their employer's best interest, most obviously where there would be a financial implication. So independent advocacy has been a key ask of the care experience community for years. This bill is our opportunity to deliver on it. The two questions I think we need to answer here, and that primarily for the government to answer, is what is independent advocacy and can we put that on the face of the bill? I have to say it's frustrating that given we've waited so long for this bill, it doesn't actually include a definition of independence. Now, that is clearly contested. I accept that. Some argue that advocacy should be provided by those who have no connection to a council whatsoever. So not just not their own staff, but also not even those from perhaps third sector or private organisations who have been contracted out. That would, in essence, require the Scottish Government to procure advocacy services and provide them nationally. But if the concern is that councils would put pressure on service providers to reduce costs, that probably only applies slightly less so to the Scottish Government, but it does still apply. So my Amendment 147, which is supported by Nicola Sturgeon, uses essentially the same language as the Mental Health Act, and as Martin Whitfield has already mentioned, is very similar to other amendments in this group. I would agree with them. Great minds do think alike. The great minds aren't sitting around this table, though. They're in the legislation team in Parliament. It uses the same definition as one that already exists in the law to define independent advocacy. I don't pretend that the language here is perfect. I've brought my amendment, like colleagues, to see what level of consensus we can achieve, and whether we accept a group of amendments at this stage and need to then reconcile them at stage 3, or collectively agree not to press based on what the Minister said. No matter what, we're clearly going to need to come back at stage 3 to settle this. For me, my decision on whether or not I move my amendment is going to very much depend on what the Minister is able to say around whether the Government believes we can, to some extent, define independence on the face of this bill, or whether the Government is arguing that that would have to be brought forward at a later point in regulation, something that I would really struggle with, particularly given the length of time it's taken us to get to this stage, the opportunity and the expectations that the care experience community have around this point in particular. Yes.
Martin Whitfield.
I'm very grateful convener. Would the member agree with me, given the discussion that has happened this morning with previous amendments, it may be useful to have something on the face of the bill at stage 2 to allow those discussions to go forward rather than it to stay silent and potentially end up in the same challenge that we've found ourselves.
Ross Greer.
That is certainly the position that I am erring towards at this point, that if nothing else, and to be completely honest with the Minister, I think from the position of an opposition member, it's useful for something to have been agreed at stage 2, because it does put, I think, a greater degree of pressure on the government to come forward with proposals for stage 3 if the government believes that what's been agreed at stage 2 is not adequate. And given that, as I said a moment ago, given the length of time it's taken for us to get to this stage and for the issue still to have not been resolved, my inclination at this point is to see something agreed at stage 2 that forces us, at the very least, to revisit the issue at stage 3.
Thank you. I call on Jeremy Balfour to speak to Amendment 8 and other amendments in the group. Mr Balfour.
Thank you, Convener. I think I start where Ross Greer finishes. I mean, I think there is a mass frustration within the community that we haven't been able to come up with a definition of independent advocate so far. And what my amendment is a pragmatic solution to this, because Bernardo said independent advocacy should be defined on the face of the bill. I absolutely agree with that. But we don't have a definition. And even in the discussions between members this morning, there doesn't seem to be clarity in regard to what independent actually means. Just 1 second, and I'll come back. The promise says that clarity about the definition of independent is vital and needs to happen. But again, I don't see us, either at this stage this morning, or even in the next 2 or 3 weeks before stage 3, being able to agree a definition of that. And I'll give way to Mr Mason.
John Mason.
I thank the member for giving way. I mean, it seems to me that both 146 and 147 do give a pretty clear definition. Now, you could maybe tidy them up a bit, but I'm certainly inclined to support one of them. And I don't see what his problem is with 146 and 147 that he feels we don't have a definition.
Jeremy Balfour.
Because I don't think that definition necessarily is inclusive enough. And in fact, maybe the opposite, it may exclude others from doing this role. You know, I think there is a genuine debate to have. Is a teacher, is a social worker, is CAB, are they all equally independent or of each other?
Where again?
Yeah.
John Mason. Thank you, Member, for giving away again. They're not independent. I think we're all agreed that they're not independent. And it does say local authority in both amendments, I think.
I think that's my problem with, I think that's my problem with this definition that we have within those 2 amendments, is that for some young people, they will be the person that they want to be the advocate for. We have seen a very similar debate, and I suppose if you hang around too long enough, these things come around. We've seen a very similar debate when we put through the bill in regards to social security, as in what was an independent advocate for somebody to be represented either before Social Security Scotland or before the tribunal.
Third time?
Why not?
John Mason.
He's very kind, I appreciate that. But surely the point is we need to define what is independent, and then it is up to the young person or whoever to choose, do they want someone who's independent or do they want somebody who's not independent, for example, a teacher or a social worker, and they would be allowed to do that. But they've still got that choice.
I absolutely agree with that, but what I want is that within the definition for it to be broader. Yeah, well, why not?
Nicholas Sturgeon.
Just to aid my understanding, is it Jeremy Balfour's position that the 146 and 147 are the minimum of what you would require, but they don't go far enough? In which case, I wonder if what we're looking to do at stage 3 is take that as a minimum and then build on it. Who Cares Scotland, for example, think this should go slightly further, and there will be other views on that. But is there an emerging consensus that this is a starting point?
Jeremy Balfour.
I welcome the member's intervention. I mean, I suppose my worry is that even when we come to stage 3, even if we can expand this further, we're not going to be able to get everyone. And I'm not sure, with respect to my colleagues and myself, we are the best people to be making that choice. And that is why I think it should be done through regulations at a future date. Now, I think what would be helpful if the Minister was at all sympathetic was we should come back with a date and set a date that has to happen, so it doesn't go on for another period of time. But I do think we...
Take an intervention?
If the convener's happy, yes.
I'm very grateful to both the convener and indeed to Jeremy Balfour for taking an intervention. Would you agree with me that given, as he has witnessed this morning, the purpose that sits behind his amendment could still be taken account of at stage 3, even if, for example, say Amendment 147 was accepted this morning?
Jeremy Balfour.
Absolutely. I mean, I think you could, in theory, accept 147 and my amendment, and then we can tidy it up at stage 3. What I think the final point I would make, without trying to labour it, is that clearly we need independence, but I think the definition needs to be broader, and I think we need to consult further with the third sector, with COSLA, and with those that have lived experience of this. And I think the quickest and best way to do that would be to do it by regulation at a future date. But I would also perhaps come back at stage 3 to put some kind of time limit on that date so that it doesn't hang around forever. Thank you.
Thank you. I call on Ros McCall to speak to Amendment 97 and other amendments in the group. Ms McCall.
Thank you, Convener. The joy of coming last in something like this is you're either repeating what everybody said or you've got nothing else to add. I think also I think it's interesting that Great Minds Think Alike has been mentioned a couple of times, because we are all trying to come together to make sure that we've got a definition of independence and have that on the face of the bill. Unfortunately, the opposite of that phrase is fools seldom differ, so I don't know where we want to go with that. I guess all I'm going to say on my amendment was to try and define a genuine independence advocacy position. Understand that may have been a little stronger and more structured than the other amendments in the group. But I think we've progressed in a debate here today where it seems that we're in agreement that there needs to be something tangible and that we want something to happen now. And based on that, I'm minded to look at agreeing with Amendment 147 and not moving my amendment. But I'm interested to hear what the Minister has to say. Thank you, Convener.
Willie Rennie.
I mean, if care experienced people had independent means, independent finance, that ultimately would be the true independence. What we have just now is too dependent on those who have responsibilities for care experienced people to determine who are their advocates. So we're looking for somewhere in between, because we're not going to have the perfect answer on this. What is frustrating that we have got to this stage without that kind of clarity being worked out, and I know there is an advantage of leaving things to regulation once legislation is passed, but too often in this place we agree the outline before we see the detail, and this is our maximum point of leverage for those who are wanting to influence this process, because once it goes into regulations, often it doesn't get the limelight that it deserves or the spotlight that it deserves. But I think ultimately I would coalesce around Ross Greer's 147, I think, as the answer, as the kind of staging post, so that we can come back at stage 3 and see if we can make a bit of further progress. But we do need to try and get these things worked out beforehand. And Jeremy Balfour is right. We're not really the people to decide. There needs to be people who have got much more of a stake in this to determine this. And it's just disappointing that hasn't been resolved before now.
Minister.
Thank you. I knew this was going to be a good debate, and it has been. I think, there is such a sense of mixed feeling around this. And it's good to hear some of that, I think. So I'll put some of my thoughts out, and then I'll sort of speak to some of the points that have been raised during the debate. The promise, of course, tells us the importance of independent advocacy services and the role that they play to support and uphold the rights of children currently in care and people with experience of care. That's why we put into the bill a commitment to provide such services on a lifelong basis. I want to thank everyone who has informed the development of the provisions at Section 4 including the Promise Scotland through its advocacy scoping report. I recognise that the issue of independent advocacy generates strong feelings. I understand that there is a desire for greater clarity around what constitutes independence on the face of the bill. I really want to set out clearly my position on these amendments and to explain why I think Jackie Dunbar's amendments 144 and 151, in my opinion, strike an appropriate balance on this important matter. Now, the bill places a duty on Scottish ministers through Section 4 to make arrangement by regulations conferring rights of access to care experience advocacy services, and the intention has always been to set out how independence is defined through regulations. These regulations will be developed in close consultation with the care community and service providers as required by... Yes.
Jeremy Balfour.
Without speaking too much against my own amendment, why has this not already happened? You know, you've had the bill coming forward for the last 2 years. You're now saying we need to consult with appropriate parties. Why is that consultation not taking place so that you could have come with an amendment or within the bill with a clear definition and then Parliament could have said yes or no to it? I'm not quite sure why we're having to do this post-legislation.
Minister.
I think there has been engagement with children and young people on a whole number of issues, and equally with stakeholders in relation to the consultations that were carried out for this bill. I think perhaps it was underestimated the mix of opinions that would be involved in relation to defining independence. And I think that's something that we've now understood through stage 1 evidence and from the clear mix of views from stakeholders and members across the chamber. And that's obviously something that I am committed to working on now, so that we have this in front of us today. I think... So, as I said, the regulations will be developed, or I would like the regulations to be developed in close consultation with the care community and the service providers. I would have been happy to go away and look at timings around this. I think the voice of care experience is absolutely at the heart of the promise, and I think it's really, I would have thought it's vital for that voice to continue to set the direction for implementation of key measures of the promise, and how the right to advocacy is defined and delivered would be one such issue. But then I understand the comments that have been made this morning around the definition of independence and whether or not a child or young person has to actually take up that offer of independent advocacy. That doesn't necessarily impact on a definition being on the face of the bill. Yes.
Yeah, I think that's an extremely good point she's made, if I'm understanding her correctly, that we come up with somewhere we come up with a definition of independence, but at the same time the person has the choice of, is it that independent person or is it someone else? And I mean, I would suggest to her that independence has been debated. We debated it around commissioners at the Finance Committee. We've debated it around accountants in my own profession. It's a spectrum. It's not a black and white issue. We will never get to a clear definition of independence that everyone accepts. But at least we've got something.
Yes, I absolutely agree. And as I say, I've followed the debate closely. I do still have some concerns around the Mental Health Care and Treatment Scotland Act 2003 definition of independent advocacy, because I know that's provided a model for Mr Whitfield's Amendment 146 and Ross Greer's Amendment 147. I think it was developed for, or I know it was developed for, the specific context of the provision of mental health care with particular safeguards and timeframes in mind. I hear what Mr Greer has said around tweaking his amendment at stage 3. I had been intending to support the amendments Jackie Dunbar was putting forward in relation to keeping independence off the face of the bill, but given the strength of feeling of committee around this, I would move members to support Mr Greer's amendment, with the thinking that we will have to come back at stage 3 to consider this further. And I would also like to ensure that to make sure that nobody is excluded from being able to provide advocacy services, that something is included in relation to a child not having to take up that offer of that independent advocate if they have a better relationship with. Just 1 second, sorry, Mr Briggs. If they have a relationship and they have a proven relationship with another advocate that is not defined as independent through whatever we get to through this bill, that they would be able to continue with that, and that puts their choice at the heart of this. So I'll take Mr Briggs' amendment and then I'll sum up.
Thank the Minister. And it's more to put on record a conversation we've been having as this committee meeting's gone on, because I think looking towards what a lot of young people are looking to, that trusted person to almost be a facilitator to access services. Now, they could be, and we don't want to take away what Jackie Dunbar has been highlighting in the sense of that's their trusted person they would want, but the conflict of interest. So I wondered in terms of, I think it's wise that we do put 147 through today, but then that definition and who the individual could be could still be looked at through a facilitator role as well, which is maybe for stage 3 to look at what that looks like and reach out to the sector to see, because I think we've all heard that voice from care experienced young people that they want that individual, even if there is that conflict of interest.
Minister.
Thank you, Mr Briggs. And absolutely, I think that's all something that can be taken into consideration for stage 3. So to sum up what I imagine was probably quite a complicated speaking note from myself, I would encourage members to support Amendment 147 and I would encourage members not to move the other amendments in this group.
I call on Jackie Dunbar to wind up and press or withdraw Amendment 144.
Thank you, Convener. I am absolutely of the opinion that my amendments 144 and 151 would have provided certainty that the independence of an advocacy services is required as part of the regulations. And listening to the room today, I am still of the opinion it's not up to us to decide who the young folk think is the best person to advocate for them. Something that Willie Rennie said was, which actually got to me, was that we shouldn't be agreeing the outline of something without the detail behind it, and I totally get that. And I would worry that if I pushed this today, we'd end up really curbing the choice of the person. So I will not press and hope it gets resolved in stage 3.
Jackie Dunbar seeks to withdraw Amendment 144. Does any member object? No member objects, so Amendment 144 has been withdrawn. I call Amendment 145 in the name of Paul O'Kane, grouped with Amendments 148, 9, 10, 96, 149, 150, 154 and 155. Paul O'Kane to move Amendment 145 and speak to all amendments in the group. Mr O'Kane.
Thank you very much, Convener. My amendments 145 and 154 would ensure that the right to access advocacy services is extended to include parents who are in contact with the care system. We know that many parents of care experienced people struggle to effectively interact with the process around hearings. The promise states that advocacy must be readily and quickly available to all families who are in contact with the care system. And I believe that these amendments would ensure that that could be realised. The Promise Scotland, as well as the National Youth Advocacy Services Cymru, argue that often parents who interact with the children's hearing system and social work services have great difficulty in engaging with the system. And I think many members will recognise that through their own discussions with care experienced people and their families, and indeed many of the support organisations that sit around about them, and indeed evidence that has been led here and elsewhere. So this amendment would enable families to access advocacy. It will make the system, I believe, more equitable and go to the heart of delivering a fairer system which can deliver on keeping the promise. Thank you.
And can you move Amendment 145?
And I move.
Thank you. I call Martin Whitfield to speak to Amendment 148 and other amendments in the group. Mr Whitfield.
Grateful, Convener. And I have 3 amendments in this group, 148, 149 and 155, and they pick up on an item that was this committee heard very strong evidence of at the stage 1, which is the geographical challenges of our rural communities. And so the purposes behind the amendments that I propose is to specifically highlight that consideration needs to be given to the rural and deprived communities so that full access is available. To pick up on Willie Rennie's comments from the previous group, if all were independently wealthy, we wouldn't have this challenge, but they are not, and the reality is that those, particularly in our rural and deprived communities, face some of the greatest struggles. And the purpose behind these amendments is to place on the face of the bill that specifically that has both been noted, as was picked up in the committee at stage 1, but also must become a specific consideration in the provision of services. And the final amendment in 155 defines deprived areas by making reference to the Scottish Index of Multiple Deprivation. Grateful.
Thank you. I call Jeremy Balfour to speak to Amendment 9 and other amendments in the group. Mr Balfour.
Thank you, Convener. This amendment is to put something into black and white so that everyone is absolutely clear that advocacy services for care experienced children is to be provided in an opt-in service. Children should always be made fully aware of their rights and options, but advocacy should never be forced upon them. By going for an opt-out model, children may feel pressurised to share their story to yet another individual who they don't know and have no connection to, and create a false demand for the service of advocates. Advocacy helps people express their views to make informed decisions. Advocates help the child and their families navigate the complex landscape and support the child and their family to make their own choices. Advocacy is different from advice, and it should not be put together. Advocacy is different from having a friend or somebody else there who you want. But advocacy should never be forced on people in an opt-out style. This goes against what advocacy means, and it could be viewed with suspicion. I will always say that insisting on advocacy will add more professionals to a cluttered landscape, and I believe this amendment puts the child's best interest at the heart of what is good for them, or what they understand is good for them. Advocacy, and then I move on to Amendment 10, Convener, seeks to ensure that advocacy is offered to the child and their families at the earliest opportunity in the hearing process. Children need to be aware of their rights at the earliest point, not at some point where someone else decides to tell them. The earliest opportunity is key to ensuring children and their families get the right support up front. And so I hope both these amendments do what the promise is meant to do, is to give some of the most vulnerable the best opportunity when going forward. Thank you.
Thank you. I call Ros McCall to speak to Amendment 96 and other amendments in the group. Ms McCall.
Thank you, Convener. I'm not going to speak for long, just on my amendment. This amendment is trying to ensure that we have the right type of trauma-informed advocacy available. Is to just to make sure that it's the right focus given to care-experienced people that require it, and to make sure that that provision is there across the board, rather than looking at alternative forms of advocacy that may be not quite as specific or as trained, and that's what this amendment is seeking to do. Thank you, Convener.
Thank you. I call Willie Rennie to speak to Amendment 150 and other amendments in the group. Mr Rennie.
Jeremy Balfour's was a devastating preemptive move against my amendment. My amendment covers an awful lot of what was covered in the previous group around about independence, so I'm not going to go back over that space. I think what's central to Amendment 150 is around about that opt-out element. And I think there is a balance to be struck, because in a very confusing, stressful environment, it may be that people, care-experienced people, don't ask for that independent advocacy. So there needs to be not quite an insistence that they take it, but there needs to be a full awareness that this is in their best interests to take that independent advocacy at that moment of stress. And that's why I wanted today, with this amendment, with the help of Duncan Dunlop, to explore that opt-out, opt-in balance. and I think it's been pretty clear. Jeremy Balfour has set out quite compelling arguments, but I'm keen to hear from the Minister how she thinks we can get that balance between those two elements, and because I think for every person will be different, and every person will require a different response from the authorities. So it needs to be sensitive, but equally it needs to be available for people who perhaps are stressed and might not want to seek advice from anybody else, even though they might actually, it might be in their best interest to do so. So with that, I will leave that and wait to hear from the Minister.
Convener, Group 10 covers a range of amendments relating to how the right to access care experience advocacy services should be delivered. A number of these amendments are connected, and I want to address the areas that these amendments cover and explain my position clearly. As drafted, Section 4 seeks to provide a right to access advocacy services for care experienced people to ensure their voices are heard and their views are accurately represented. Paul O'Kane's Amendment 145 expands that right to advocacy support to family members of people with care experience. Now, I agree that families should be properly supported. However, I'm mindful that advocacy can be, but it's not always the answer. And I think it's important that we understand how other routes to providing support to families, such as through whole family support, have a role to play. I have concerns around whether a widening of the right to access advocacy support that will be designed for the specific needs of people with care experience is the most appropriate route to making sure that families have the support that they need. Paul O'Kane's Amendment 154 would place a requirement on Scottish ministers to consult with families of care experienced people when developing regulations, yet Section 4.7 of the bill already provides that Scottish ministers may consult with other persons in developing the regulations. This allows Scottish ministers to consult with family members if they deem it appropriate. There is no need for an additional requirement of this on the face of the bill. So I hope that reassures Paul O'Kane and he will not press his amendments. Martin Whitfield's Amendments 148, 149 and 155 seek to ensure the needs of care experienced people in rural and deprived areas have access to advocacy services through this bill. I know that the delivery of advocacy services in rural and island communities can be particularly challenging, often with fewer advocates covering vast geographical areas. Section 4.3 of the bill already places a duty on Scottish ministers to ensure that care experience advocacy services are available to each person who has the right. This duty does not distinguish between urban or rural areas or between deprived and less deprived areas. It is universal. And to fulfil this duty, Scottish ministers must ensure that every care experienced person, wherever they live, can access advocacy services. I would therefore say that these amendments are unnecessary. But I think it important to highlight the points. In Yes?
Martin Whitfield.
I'm very grateful for the Minister articulating what already exists within the bill and the proposals, but also the absolute obligation that rests on Scottish ministers to ensure that the availability of the advocacy and other services across now. Welcome that undertaking. Thank you.
Minister.
Thank Mr Whitfield for that intervention. In developing the regulations, we will consult carefully with the care community and the service providers, including those from rural and deprived areas, about the challenges that they face. And if we need to address the specific circumstances of care experienced people, including where they live, then that can be addressed in the regulations through subsection 4. Regulations are a more appropriate way, I think, to enable a tailored and future-proofed approach to meet the needs of the care experienced community, both now and in the future. Moving on to Amendments 9 and 10 lodged by Jeremy Balfour, I understand the intention behind these amendments. Amendment 9 would require that regulations conferring rights to care experienced advocacy services ensure those rights are conferred on an opt-in basis. And this, I think, reflects what we've heard consistently from stakeholders about the importance of choice and autonomy. Amendment 9 preserves that choice. Care experience advocacy will not be a one-time offer, and if someone chooses to opt in at a later stage, then they absolutely have the right to do so. Amendment 10 would require that regulations make provision to ensure that care experienced advocacy services are offered at the earliest appropriate opportunity. This would help ensure that care experienced people have access to advocacy support when they need it most. We know that care experienced people have diverse needs and circumstances, entering the care system at different points, through different routes and with different vulnerabilities. So what is the earliest appropriate opportunity will vary depending on an individual's circumstances. Amendment 10 allows the regulations and guidance to be tailored to these diverse circumstances. It will help ensure that care experienced people have access to advocacy support when they need it most in the way that is most appropriate for them. However, I do just have some concerns around how these are currently drafted, and I would like to work with Mr Balfour ahead of stage 3 to reflect the intention, because I do believe that these reflect the priorities of this provision. Ros McCall's... Yes, of course.
Jeremy Balfour.
Just going back to is this an opt-in and opt-out? So is the Minister happy to have these accepted today and then to redraft them? Or, because that would be my preference, so that they aren't forgotten about, rather than them not being moved today and something else coming forward?
Minister.
Yes, I would. Sorry to cut across you there. Yes, I would. Ros McCall's Amendment 96 would prohibit regulations from taking into account the availability of other advocacy services when determining access to care experience advocacy. Scotland has a very complex landscape of existing advocacy provision. Care experienced people might already have access to advocacy under existing entitlements. The intention of the bill is not to cut across these existing entitlements. Rather, it's to establish a new lifelong right, whilst recognising that existing entitlements might be more appropriate in particular circumstances. And if accepted, this amendment could create a risk of duplication and confusion. We could end up in a situation where someone has, for example, a mental health advocate and a care experience advocate supporting them at the same time. And I don't think that's good for the care experienced person or a good use of resources. I've heard repeatedly from stakeholders of the importance of ensuring that advocacy is relationship based and responsive to individual needs, and in some cases the most appropriate route may be for a care experienced person to access existing advocacy services, particularly if that is their preference. The bill already gives Scottish ministers the power to specify in regulations the circumstances in which the right to care experience advocacy can be exercised. Amendment 96 would also remove the flexibility that the bill's structure provides to develop a nuanced approach that ensures care experience advocacy services are available whilst not cutting across existing entitlements. I therefore ask Ros McCall not to press Amendment 96. If she's minded to press, I would ask the committee to vote against. Now, I understand Willie Rennie's intentions behind his amendment 150, and I know that some stakeholders have argued strongly for this approach. I think another issue that is contested greatly in terms of a differing opinion. We all want to ensure that care experienced people have access to high-quality relationship-based advocacy, and I do agree with some of the principles inherent in this amendment. I agree with Willie Rennie that advocacy should be relationship-based and built on trust and continuity. Advocates should be able to attend key meetings and decisions. There should also be transparent monitoring of effectiveness. These are operational matters that should be covered by the regulations, and following consultation with the care community and service providers, I would hope that that would be the case. But I can't support the other matters he considers should be included in those regulations. The requirement that advocacy services be fully independent from local authorities and care providers. Well, we've gone over this. Sorry, I'll come back to that. I think there's another serious concern with the opt-out model, though, and I think it's in that it could create a power imbalance with pressure falling on care experienced individuals to either dismiss or to resist the allocation of a professional advocacy worker. And I think this is really problematic for children or care experienced people with complex communication needs who might find it difficult to actively refuse advocacy support. The right to advocacy should be based on informed consent and not on assumed consent that individuals have to actively refuse. So while we might agree on some matters around this, I cannot support others. So I will take Mr Rennie's.
Willie Rennie.
Sorry to interrupt. But does equally the power imbalance not operate the other way as well? That if the care experienced person believes that they have to ask for something, is that not in itself daunting, having to choose where to go? Is that not something the Minister's considered? How do we get that balance right between those two opposing elements?
I agree it's difficult to strike the right balance, and I think that is a good point. But I think the opt-in still leaves the choice in the child or young person's hands, rather than feeling like they're having to say that they don't want to take that. I still think that is more centred around their opinion. So that would be my answer to that. As I said, I think we do agree on some points around this, not all of them. So again, I think we could, consider what we could do ahead of stage 3. So in conclusion, while I cannot support some of the amendments as drafted today, I do welcome the opportunity for further discussion ahead of stage 3 on amendments 9, 10 and 150 to reach a point where we're confident that these are drafted in a way that best reflects the intention. If Paul O'Kane, Martin Whitfield and Rose McCall are minded to press their amendments, I would urge the committee to vote against. If Jeremy Balfour presses amendments 9 and 10, I'm happy to support, given further discussion. And if Willie Rennie presses amendment 150, I would ask members to vote against.
Thank you. I call Paul O'Kane to wind up and press or withdraw Amendment 145. Mr O'Kane.
Thank you very much, Convener. I think that has been a fairly fulsome debate in terms of the importance of advocacy and of understanding the scaffolding and ancillary services that are required to support care experienced people. I recognise much of what the Minister has said in terms of her willingness to engage with other colleagues ahead of stage 3. I do feel that it is important that we explore this issue of the wider role of advocacy, particularly for parents and families. I recognise what the Minister said about provisions that already exist in terms of supporting advocacy, and of course the difference that will exist in terms of how people would access and require advocacy. I think given that undertaking and the undertaking she gave to Mr Whitfield in terms of his amendments, I would be happy to withdraw my amendments at this point and re-engage ahead of stage 3.
Paul O'Kane seeks to withdraw Amendment 145. Does any member object? No member objects. Amendment 145 is withdrawn. I call Amendment 146 in the name of Martin Whitfield, already debated, with Amendment 144. Martin Whitfield to move or not move?
Not move.
I call Amendment 147 in the name of Ross Greer, already debated, with Amendment 144. Ross Greer to move or not move?
Move.
The question is that Amendment 147 be agreed to. Are we all agreed? Yes. That is agreed. I call Amendment 148 in the name of Martin Whitfield, already debated, with Amendment 145. Martin Whitfield to move or not move?
Not move.
I call Amendment 8 in the name of Jeremy Balfour, already debated, with Amendment 144. Jeremy Balfour to move or not move?
Not move.
I call Amendment 9 in the name of Jeremy Balfour, already debated, with Amendment 145. Jeremy Balfour to move or not move?
Move.
The question is that Amendment 9 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 9? Those against Amendment 9? Thank you. Thank you. The result of the vote on Amendment 9 is yes, 0, no, 10. Amendment 9 is therefore not agreed to. I call Amendment 10 in the name of Jeremy Balfour, already debated, with Amendment 145. Jeremy Balfour to move or not move?
Move.
The question is that Amendment 10 be agreed to. Are we all agreed? We're not agreed. There will be a division. Those in favour of Amendment 10? Thank you. And those against Amendment 10? Thank you. The result of the vote on Amendment 10 is yes 5, no 5. As the outcome of the division is tied on Amendment 10, I will now use my casting vote as convener in order for the committee to reach a decision. I vote in favour of Amendment 10. Therefore, the committee agrees to Amendment 10. I call Amendment 96 in the name of Ros McCall, already debated, with Amendment 145. Ros McCall to move or not move?
Not move.
I call Amendment 149 in the name of Martin Whitfield, already debated, with Amendment 145. Martin Whitfield to move or not move?
Not move.
I call Amendment 150 in the name of Willie Rennie, already debated, with Amendment 145. Willie Rennie to move or not move?
Not move.
I call Amendment 151 in the name of Jackie Dunbar, already debated, with Amendment 144. Jackie Dunbar to move or not move?
Not move.
Thank you very much. That concludes our consideration of the bill at stage 2 today. Can I thank the Minister, her supporting officials and all members for their attendance. The committee will continue its consideration at its meeting on the 11th of February, and I close this meeting.